My lord, I beg to mention item number 20.
20.
20.
For hearing.
Yes.
Okay. What happened?
Don't
Don't want to do it.
Matter may be listed after vacation.
As prayed for by the counsel. You are for the petitioner.
Yeah.
And you have informed the other side.
Yes, yes.
As prayed for by the counsel, appearing for the petitioner, list the matter after the vacation on a date to be fixed by the registrar. Which was not objected. He has taken consent that life.
Lordship, I beg to mention one I criminal number to 12 of 2024 in criminal appeal, which may be kindly taken up tomorrow.
I for
Yes. I is for bail.
suspension of sentence. In
Uh,
criminal appeal.
Criminal appeal.
So
Jail appeal.
suspension of sentence.
Yes.
Why tomorrow? Next week?
Lordship, this matter was last listed on the month of April.
Next week is a
Yes,
holiday.
yeah.
So do it after the vacation. Otherwise, he is inside the jail after the conviction.
Yes, he's inside the jail. So kindly taken up tomorrow. It has to be lifted after 4 weeks. Returnable was 4 weeks, but it's been 2 months, more than 2 months.
Tomorrow there are many matters. Yesterday so many councils mentioned, and so I had to list it. So day after tomorrow. Okay. On Wednesday. On Thursday.
That's right.
Yeah, your lordship.
Lordship, I beg to mention item number 7. Lordship, leading counsel is out of station. Kindly, any fixed date may be given, Lordship.
Here for petitioner.
Yes, Lordship.
The
Item number 7.
Mr. V. Jamo is out of station.
J. Jongluju.
J. Jongluju.
Yes,
Okay.
Lordship.
The counsel appearing for the appellant states that the conducting counsel has some personal difficulty and so he cannot appear today. Matter be listed. You have informed the other side?
Lordship, I could not contact them.
Inform them.
Yes, Lordship.
Otherwise, it's between private parties.
Lordship, if matter may be fixed after the vacation. Any fixed
If
date?
they somehow come, then order might change. Then listed after vacation as well. There are so many counsels for the respondents, we could not contact any of them.
Yes, Lordship, I was unable to contact them, but I will inform.
You will inform them as soon as possible.
Lordship, any fixed date?
Okay, after the vacation, you do
By-
it on 24th
Lordship,
or 29th? Okay.
7th of August, if possible,
Okay.
Lordship.
Listed on 7th of August. You inform the other sides.
Obliged, Lordship.
Lordship, I would like to mention item number 14.
14.
Yes.
This is for orders. Let us
Yes.
see why it has come up.
On last occasion, lower court record was called for.
Ah.
So it has been received.
It has been received.
Yes.
So,
Matter may be,
order matters, so
yes,
it will-
taken up maybe list after vacation
as prayed for by Mr. So-and-so.
for the petitioner.
List the matter after vacation on a date to be fixed by the registrar.
Early of that. Interim order is used.
Huh.
Interim order is there.
Or interim order passed earlier shall continue till the next date.
Lordship,
Yes.
I'm mentioning one WPC matter which may be kindly listed tomorrow in other column. We have to do some necessary correction. WPC 270.
Why do you want it to come up tomorrow?
Actually, here, Your Lordship, notice was issued. We took the step, but now the address has been changed. So we have to issue notice again in the new address. For that, we need direction from this honorable court.
Listed for orders day after tomorrow. Day after tomorrow will do.
Okay, can it be out tomorrow?
Tomorrow there are so many
Okay.
matters. Again, it will
Okay,
not
no
be
issue, no
changed,
issue,
right?
no issue.
Day after.
May I, Your Lordship? Your Lordship, I beg to mention item number 19. Your Lordship, the leading counsel M. Kato could not appear due to the personal difficulties.
2014 criminal appeal. Look, 11 years have gone by.
Your
Where
Lordship,
is
due to
Mr.
some
M. Kato will appear?
yes, Your
Where
Lordship.
is Mr. M. Kato?
Due to some personal difficulties, he could not appear. Your Lordship.
This is the last opportunity because this is 2014 appeal. No further adjournment, right? Miss so-and-so?
Your Lordship, the matter may be listed after 4 weeks.
I'll give a fixed date and that day you'll have to do no further adjournment.
Because let the matter be fixed after 4 because what happened in this
Your
case?
matter.
Yes, ma'am.
You were
When-
supposed to, you wanted to do the
When I
matter.
am present, he remained absent.
Oh.
So when he is present, sometimes I also remain absent. So I want the matter fixed after 4 weeks so that we can discuss the matter and we'll get it fixed on particular day.
You are for respondent.
Yes, ma'am.
You are Mr. S. Koya.
Yes, ma'am.
I'm
on a
proceed.
Yes, on a joint prayer made by the counsel appearing for the petitioner as well as the counsel appearing for respondent number. It is a appeal against acquittal.
Not acquittal, conviction, conviction.
It is for enhancement of sentence.
Enhancement of sentence. That is why I'm seeing 3 parties here, so I thought, okay, on a joint prayer, list the matter after the vacation,
After 4 weeks.
after 4 weeks. After 4 weeks, so and so is present. Since the matter relates to the year 2014, it is as such directed that the case to be done, the hearing of the case needs to be done on the next date of listing.
Much obliged.
May I, my lord? My lord, I beg to mention item number 8.
Wait,
My lord, this morning only we have filed Bakalatnama for the respondent. So matter may be list after 4 weeks.
okay, right. Mr.
Omodi.
Acha, Mr. So-and-so, appearing for the respondent, states that he has filed the Wakalatnama on behalf of respondent number 2 this morning, and as such has prayed for some time. The matter prayer is allowed. List the matter after 2 weeks.
My lord, 4 weeks.
Why 4 weeks?
Then,
This is related, this is a revision between 2. It's a matrimonial issue or what? Don't know.
okay, 2 weeks, my lord.
After 2 weeks, on a date to be fixed by registry.
Obliged.
Your Lordship, I beg to mention item number 4. For adjournment, senior counsels out of station.
Item number 4.
Meet and Akum versus State VP.
Mr. So-and-so appearing for the petitioner states that the conducting counsel has some personal difficulty and has prayed for some time. Prayer is allowed. List the matter after the vacation.
My lord,
How much obliged me?
Yeah,
yes, I put up a petitioner here, madam.
you are for respondent.
Sir?
He's mentioning item number 4.
566, sorry, my lord. My lord,
This
666.
big
I'm sorry,
mistake. You should not.
my apologies. My apologies. Item number 6. Item number 6.
Pass it in item number.
Item number
6.
6.
Don't do it again. List after 2 weeks.
My lord,
Yes.
this revision petition, my lord, is in fact, my lord, directing against the order, my lord, of ADC come Assistant Commissioner, my lord.
It is against.
I will against the.
Seva decision.
No, my lord. My lord, what happened before coming to the impugned order, my lord? Let me highlight the fact, my lord. My lord, there was a contractual agreement in between 3 persons, including the petitioner, my lord. All them of unemployed youth. So they were looking for this contractual work, and luckily, fortunately, they got one contractual work here at Sagali. They executed it partially, but it was jointly executed. But before execution of the work, contractual work, since they do not have the money, so they do not have the money for this purchasing of the materials. So one of the person, yes, our partner, he took a loan from someone,
Private loan.
a private loan of 5 lakhs rupees. So we started execution of the work, but we could not complete the execution of the work because the person who has borrowed the money from other person, he surrendered and he approached the authority corporation that he will not be continuing the work. That document I will show my lord later. Thereafter, since the contract was not my lord continued, so he lodged a complaint before the Keba.
Who lodged? The one who surrendered?
Yes, my lord.
Ah, yes.
And in the Keba decision, my lord, the Keba has passed that, my lord. Since my lord may kindly note, initially there were 3 partners. In the first Keba decision, my lord, I will come to that. I will show the document later. In the first Keba decision, the Keba has decided that both the petitioner and other person has to pay back rupees 7,80,000 to the decree holder, the complainant in the Kaba. So Kaba has passed that order. Thereafter, another Kaba was held, my lord, where only the petitioner made the party.
Complaint was only by petitioner.
My lord, yes. No, complaint was initiated by the decree holder. So in the first Kaba, the decision was that both petitioner and the other person
Will pay that.
yes, that amount. And second, in the Kaba decision, it was only directed against me. I have to pay the whole amount. He has been, my lord, without any assigning reason, he has been absolved from the liability. So, my lord, on the basis of that decision, the judgment decree holder, he filed an execution petition before the ADC. Thereafter, it proceeded. But while the execution petition was pending, the judgment debtor, he filed a civil appeal before the Civil Justice Senate Division, ALO. So after filing of that civil appeal, in fact, it was not filed within the limitation period. So another IA was filed along with them for condemnation of the delay. So delay condemnation, my lord, a notice has been issued for delay condemnation to the parties. So therefore, when this execution petition was being taken up by the additional deputy commissioner, I have apprised the additional deputy commissioner that I have filed civil appeal before the Civil Judge Senior Division, and therefore kindly hold the execution proceeding. So that also I have submitted the representation and objection. That was not considered. So ADC went on proceeding with the execution petition, and he has finally issued warrant against me. That warrant is not yet been executed. So therefore, I am before your lordship. Now let us, lordship, discuss.
For the DC executing the decree, executing the decision of the KEBA,
Yes.
there is one provision, I think, section 27 of the Arunachal Pradesh Civil Code Act, what he has to do if there is any appeal file. Do you have that section?
No, my lord.
27 was amended. Yesterday, one of your counsel placed it before me. There was an amendment in the Assam Frontier Regulation.
Amendment, my lord. Yes, there has been several amendments, my lord, but I'm fairly submitting.
But the decree has to be, the decision has to be executed within a period of 30 days, and if it cannot be done so, DC will do it, DC will execute it. And there is a proviso also, something.
My lord,
Because you have placed before the DC that you have filed a civil
yes, ma'am.
appeal.
Yes, ma'am.
Instead of that, in spite of that, the DC is proceeding to execute.
Yes, ma'am. Yes, my lord.
Yes.
Yes,
And
my
he
lord.
has,
Here is,
so issued.
yes, warrant against me,
Good job.
warrant against me. So in that case, if this, the impugn order passed by the AJ, ADC is not stayed, finally, this appeal before the civil judge senior, it will be
Your
different.
appeal is against the Kebang decision.
Yes, yes.
I think the appeal after the Kebang lies before the DC.
No, no.
It lies before the civil court.
Yes, civil court.
Under the Arunachal Pradesh civil court.
Yes, yes.
Show me that provision.
My lord, I could not have that right now, the copy.
Actually, you go the way you want. There. Hmm.
My lord, I am not, in fact, I am not challenging the jurisdiction here.
Hmm.
Only, my lord, my submission would be that, my lord, since, my lord, I have filed the appeal, that,
Hmm. I have the book.
my lord, yes, it is in section 15, my lord, yeah, 15 years.
1/5.
1/5, yes, 1/5.
What does it say? Just read it out.
It says, appeals from the decree or order passed by court of district judge, no,
No, appeal from the village court. Village.
Yes, my lord. Appeals from the decree or order passed by court of district judge and court of an additional district judge in original suits and proceeding of civil nature shall, when such appeals are allowed by law, lie to the High Court. Appeals from the decrees or order passed by court of civil judge senior division in original suits and proceeding of civil nature shall, when such appeals are allowed by law, lie to the court of district judge of that district or in the court of additional district judge where such court exists or the court as the case may be. Now,
No, it doesn't speak of.
yeah, my lord,
the-
it doesn't exhaust here, my lord. Now, 3 says,
It says from appeal from the decree of the order passed by the district judge and courts of an additional district judge. I'm speaking of what happens from an order of the customary court, the village court.
my lord, section 15 does not end here, my lord. I have read up to, yes, read up to, my lord, section 15, clause 1 and 2. There is a provision provided in this section, my lord. It says, my lord, in the last provision, my lord, provided further that from the date of commencement of this act, in case an appeal is prepared against the judgment of a customary court in the court of district judge or in the court of additional district judge, as the case may be, the court of district judge or the court of additional district judge may dispose of the same or proceed with
Dino.
case dino.
So your appeal lies before the district judge, not to the civil court.
My lord, yes, as per this section, my lord, it ought to have been filed before the district judge. In any case, my lord, if as per the CPC, my lord, if a plaint is presented to a
That is
forum, my
different.
lord, it has to be written. It has to be written, my lord.
Ah.
It has to be written. It does not dismiss even if a plaint is present before improper this forum. It has to be, my lord, returned back to the plaintiff. Until it is dismissed, my lord, it holds, my lord.
Until it is returned back.
Yes, my lord.
I want to say that, yes.
At least, my lord, at this stage, my lord. Since, my lord, the maintainability itself is not being raised before the civil court. Of course, my lord, if the party comes, tomorrow we have, the court has already issued the notice. It, yeah,
You prepare the case and come.
my lord, the thing is,
There is some amendment.
my lord, yes, my lord, even after this, my lord, now I have been, yes, told my brother that a subsequent amendment has been made, my lord, in the year 2023.
23.
Yes, my lord. In AFR, some procedure regulation,
Which amendment you are talking of?
that amendment, my lord, This is the compilation of all the amendments, my lord, all the amendments. In section 24, my lord, compilation of all the amendments, my lord, last Friday I have a matter here, my lord. We are discussing on this issue, my lord. And I have placed three amendments, my lord,
Substitution of section 24.
my lord.
This is on 2023.
My lord, this is compilation, yes, my lord. Yes, 2023 compilation, my lord. That, my lord.
Anyway, prepare the case and come, because otherwise your appeal is wrong. Your appeal should be before Deputy Commissioner, as I can make out. Of course, if there are
No, my
amendments.
lord, that has been done away with, my lord. Now,
Show me the amendment then, properly.
my lord, this section for 34, my lord, of the compilation, my lord, since I have not.
Are you
Yeah.
bring the
My,
printouts and all?
my lord, may kindly take up this matter at 2, my lord. Because,
Okay. At 2.
yes. Oblige, my lord. It's appropriate, my lord.
Bail application.
My lord, I may be allowed to this matter for some necessary correction. So here, yes, the offense, alleged offense is for bailable offense. And bailable offense was rejected by Lane District Court, District Session Court. And here file 483. So I need some correction. For that, I file application for correction and matter may be fixed.
So you have to withdraw it and file it there.
Just converting, I file converting application for converting this bail application to revision. So it will, I pray for matter
Okay,
maybe
we'll,
fixed tomorrow or day after tomorrow.
Then you withdraw this petition.
No, just
want to
this,
amend?
yes,
This has to be
Praying-
considered a civil revision.
praying for this bail application into criminal revision. Yes. So for that, I have filed application.
That application
This
is
morning I have filed.
not on board today.
Yes, that is I pray for this matter may be released tomorrow or day after tomorrow.
But see, if wrongly an appeal is filed and you want to convert it to revision, then it is done.
Yes.
But this is a bail application which you want to convert it to revision.
Discretion, I have filed application for 528. So discretion is up to discernible court, either
Better
accept
you
or
withdraw it and file a new revision.
no problem.
application.
It may be done, no problem.
Because even the cost title and all you'll have to change. All bail
The
applications.
entire thing, the things will be same. Only the registration, the criminal bail application into.
Change will be different. It's better you withdraw and file a revision petition.
All right.
As prayed for by Mr.
T. Torum.
D. Torum. Mr. D. Torum submits before this court that mistakenly he has filed the instant application as a bail application, and as such, he desires to withdraw the same. The prayer is allowed. Withdraw the same and file the correct application as per law, where prayer is allowed. This application is disposed of.
All right.
Disposed of. Disposed of is withdrawn.
Please, Your Lordship. Your Lordship, this is an bail application filed under section 483 of BNS for the release of the alleged accused person who has been arrested on 21/3/2025. May I read the FIR?
This is under section 6 of POCSO.
Yes, Your Lordship.
And
Actually,
this-
Your Lordship, the matter is pending in the stage of evidence. On 19th of March, 18th of March, the matter was fixed for PWS. But due to the overlook by the council, I could not able to contact the accused person. As such, the NBW, non-bailable warrant of arrest was issued against the alleged accused person. So on 23 March 2025, I have filed one application for the recalling of the order dated 18 March 2025. But for the recalling,
Recalling, okay.
yes, for the recalling, but the learned session, special judge could not allow, as such the alleged accused person has been arrested.
Acha.
Your Lordship, Your Lordship, may I read only the relevant portion?
Hmm.
Your Lordship, kindness is para 6.
Of your petition.
Yes, Your Lordship, where I have mentioned that the ground for absent was neither the intention nor the deliberate.
Paragraph what? 6.
Yes, para 6.
Para 3.
6.
6 is Seven Sisters Home.
No, Your Lordship, that is the inside the FIR only. 6, that page number 8. Para 6.
Page number 8.
Yes.
What is this? Oh, these were subparagraphs.
Yes, FIR. Part of the FIR.
Oh. So this is FIR. You have quoted the entire FIR here.
Yes.
6 is.
Your Lordship, on dated 21 March 2025, the alleged accused person has filed one misapplication for recalling of the non-believable issued against on 18/3/2025 before the learned trial court. However, the same has not been allowed by the learned. It is observed by the learned court that the case was fixed on 4/10/24 and 18/12/24. However, on 4/10/24, the accused person remained with step, and on 18/12/24, no hearing could taken place as the due to the absence of the PO. Actually, Your Lordship, then the matter has been fixed on 8/3/25. So, on that day, the accused person was found absent. On that day, also the present witness was also present. Further, it is also observed by the Honorable Court that due to the absence of the accused person, the trial of the case could not be proceeded, and accordingly, the alleged accused has been taken into custody. And Your Lordship, till today he is inside the 99 days. Moreover, Your Lordship, he was very regular. On that day only, due to the overlook by the council only, he was not appear. That's the ground only, Your Lordship.
Earlier also he remained absent with steps.
Yes, Your Lordship.
Okay. Show me the rejection of the recalling order.
Your Lordship, kindly see. Yeah, Annexure 5. Page 21, 22, 23, 24. Case record put up today along with criminal miscase filed by the applicant accused person.
This is on 21/3 and he absented himself on 18/3.
Yes. For the recalling of the cancellation of NBW issued against accused person on 18/3/2025 was counted. I have heard submission made by the learned PDC. It is submitted that on 18/3/25 the case was fixed for examination of the PWs, whereas the council could not provide the date to the accused person, and on 19/3/25 a telephonic call was received informing that warrant was issued against the accused person due to the overlook of the cause list by the council. It is submitted that in the cause list, name of advocate L. Gillen was mentioned instead of Searing. It is phrased that non-appearance of the accused is non-intentional, and the warrant of arrest issued against the accused may be cancelled. I have carefully perused the record of the case and found that the present case was initiated against the accused person alleging commission of offense under Section 6 of POCSO Act, where alleged accused has committed sexual intercourse upon the minor victim of 15 years, making her pregnant, and she has given birth to a FSL revealed that the accused person is the biological father of the newly born child. It is also observed that charge sheet in the present case is filed on 6/9/22 and as provided under Section 35(2) of the POCSO Act, an offense under Section 6 of the POCSO is to be completed within the period of 1 year, but even more than 2.5. year is already completed, the trial of the case could not be completed. It is also observed that the case was fixed on 4/10/24 and 18/12/24. However, on 4/10/24, the accused person remained absent with step, and on 18/12, no hearing could place step due to of this court. Though the case was refixed on 18/3/25, the accused person found absent without any step. On that day, the witness was also present. It is observed that due to absence of the accused person, the trial of the case could not be proceeded, and accordingly, alleged accused person has been taken into custody of the court.
Achha, this special judge POCSO, he is hearing the matter. He is the trial judge, the one who has passed this order.
Yes.
Does he have the power to recall his orders?
Lordship, in the same court, Lordship, it can be Lordship. But the reason thereby is given, Lordship, why it is not been recalled, and the same day, Lordship, the accused is made under custody, Lordship. The reason here given that, Lordship, because of this remain absent, the trial is kept pending for 2.5 years, Lordship. As per the section 35(2), Lordship, it should be completed with the stipulated time of 1 year. So because of non-appearance, Lordship, it is getting delayed. That reason is cited here in the order.
It has already got delayed 2.5
Yes,
years, but he
Lordship.
was absent for only 1 day.
Yes, Lordship. That is the discretion of this court, Lordship.
But recalling power he has, right?
Yes, Lordship. In the same court, Lordship.
In the same.
Yes, Lordship.
Does the provision, what does the provision say?
Lordship, in the provision, Lordship, in the Lordship, BNS 72, 2, Lordship, clause 2.
72.
Clause 2, yes, Lordship.
Give me BNS. BNS is. Which one you said?
72, clause 2, Lordship. BNS.
Every warrant of arrest
Yes, Lordship.
issued by
Remain in
court
force
under
until
shall be
cancelled by the
granted
court is
final
issued it until it is executed.
by the court which issued it.
Yes, Lordship.
Or until it is executed. Acha, acha. So what I'm thinking is he was absent for only 1 day.
Yes, Lordship.
And that too, it's a pleaded case that the council did not inform him, right?
Yes.
So in that case, Lordship, it may be, if Lordship deems fit, then it may be given chance to appear, but without any delay or without absent, Lordship.
Yes,
So
then
the trial.
I'm ready to comply
Yes,
any
Lord.
kind of terms
He
and
has to
conditions.
wait, he has to go on each and every day with the
Yes.
conditions I'll give.
Yes, Your Lordship.
Right, so her, Miss,
C. Iring.
your name is there in the
C. Iring.
C. Erin.
Yes.
Yes, heard Miss C. Erin, appearing for the applicant. And Miss Lakshmi Hage for the additional public prosecutor. This is an application filed under section 483 of the BNSS for release of the, for bail of the, for grant of bail of the accused person, namely Shri Motala Wali, arrested on 21/3/2025, who was arrested on 21/3/2025. In connection with, no, not in connection, he was arrested on so and so. The fact of the present case is that in pursuant to the FIR, the petitioner was arrested and he was released on bail. When was he released on bail initially? No idea.
Yes.
He was released on bail in connection with the, what did you say? In pursuance to an FIR lodged under section 6 of the, under section 376 IPC, read with section 6 of the POCSO Act. And case number you give, ITA WPS police station case number 29 of 19. He was arrested in connection with ITA WPS so and so, and he was released on bail in connection of the said case. Thereafter, charges were framed and the trial proceeded. Thereafter, charge sheet was submitted, comma, charges were framed, and the trial proceeded.
Lordship, this is the, he is just punished, Lordship.
Okay. Matter that is not the
Yes,
issue
Lordship.
actually. He was granted bail on 22/12/22. And the trial, trial proceeded. During the trial, when the witnesses were examined, he did not appear. The accused person did not appear on one day, that is on
18 March.
19/3.
18 March.
18/3/2025. Full stop. The petitioner stated that the, 18/3/2025 on the ground that the counsel appearing for the petitioner did not provide the date on which he was supposed to appear. That is on 18/3/2025. Due to the absence of the accused person, the Special Judge POCSO, Papampare District AP, Papampare District, where is it written, the issue of NBW? Where is that order? Oh, yes. Papampare. He was absent without steps. He did not appear without steps and was absent without steps. The Special Judge POCSO, Papampara District, issued NBW against the petitioner with the notice to his bailer and fixed 29/5/2025 for production of the accused. Full stop. On 21st of March 2025, an application was filed before the said special judge for recalling / cancellation of NBWA issued against the petitioner for his non-appearance on 18/3/2025. The Learned Court of Special Judge POCSO however rejected the application on the ground that due to the absence of the accused person, the trial of the case could not be proceeded, and accordingly, the accused person, that is the petitioner, was taken in custody of the court. Against the said rejection order, the petitioner is before the court. In the instant bail application. You could have actually filed an application for setting aside of this order instead of bail.
Okay, next time.
Could have come in criminal revision, actually.
Could have come in
Yes,
revision against this order,
Yes, Lordship.
but she has come for bail. Whether this is maintainable.
Lordship, here, Lordship, in the POCSO and victim also not been made party, if it is
Yes.
bail, Lordship.
Hmm?
It is, if it is bail, then Lordship, in the POCSO matter, victim should be made party. And it is victim also not made party lawsuit. But
In
lawsuit,
every steps.
yes, lawsuit.
Moreover, Your Honor, the victim complainant, they have already been examined. Only the one witness is only remaining in this case.
No, that is okay, but the requirement by the Supreme Court is that at every stage victim has to be heard. Now that you are no longer on bail, you are inside. So you have to be again given bail on fresh circumstances. So she is right in saying that you have to make victim the party here. Right. Cut the last line. Full stop. The applicant has approached his court by filing a bail application on behalf of the bail application under section 483 of the BNSS 2023. Instead of filing a revision petition challenging the order dated 21/3/2025 passed by the Special Judge POCSO. And also, without making the victim as a party respondent in the said proceeding. As it is held by the apex court that in cases under the POCSO Act, the victim is required to be made a party and should be heard at every stage. What did I write? And as it is cut as, and it is held by the apex court. That so and so has to be heard. What should be the procedure? Bail or
Lordship, it would be lordship appropriate if she withdraw and file afresh in the criminal revision petition lordship.
that should be the actually.
And victim
Otherwise,
also made party lordship.
there is no bar. I don't
Yes,
think so.
lordship.
There will be any bar in filing bail.
Yes, lordship.
But then the proper course would be
Yes,
division.
Lordship,
You file it the same thing.
allow with liberty.
As such, the counsel, the petitioner is allowed to withdraw the instant application and file an appropriate application as per law. Full stop. The matter is dismissed as withdrawn. I have already given you, you can file appropriate application as per.
My lord,
Petition. Oh, no.
my lord,
Which one?
surprisingly, my lord, this is item number 4, my lord. The special court, my lord,
Ah.
POCSO, has granted the
21st, on 21st, right? List the matter on 21st of August or July 2025.
My lord, the victim is not the complainant. The father is the complainant, my lord. My lord is
Acha, to cut the victim, let only complainant stay.
May I please? My lord, here, application file under section 528, allowed it was,
For
yes, 480, 584. My lord,
what
here,
FIR?
quashing the FIR. The FIR, this is counter FIR. Earlier,
Only FIR, no charge sheet, no? Not submitted.
not charge sheet.
Okay. Hmm.
Earlier, this is a land dispute
Hmm.
between the present complainant and the LPC holder.
Land dispute.
Yes.
So you want to
And,
say it's a civil matter?
Yes, completely civil matter. And moreover, in the FIR, there is no plausible explanation has been recorded because this alleged incidence of offense took place in the year 2010. And now here FIR is law in 2025 after lapse of 15 years. So as per the
FIR, there has to be some reason.
FIR is page number 20.
What is 16? F16?
May I read the FIR?
16 is the FIR.
No, there are three FIRs.
Acha.
Earlier FIR, that is present LPC holder lodged a FIR against the present complainants, alleging that they have encroached upon the allotted land of the landholders, private land. And thereafter, in retaliate manner, in reference in counter in retaliate manner, because present petitioner is the clan member of the LPC holders. On the basis of that, the present
LPC means the possession certificate.
yeah, land LPC means land possession certificate. Before going to the present FIR, my lord, kindly peruse the page number 17, page number 16. This is a past FIR, and page number 17 is type of coffee. FIR against unknown culprit for illegally trespass into my private allotted land.
Wait, 1 second.
Yes, this is a past
Who
FIR.
is the petitioner here? Nara
Nara
Loma.
Loma. Yes.
Okay.
This is nowhere connected. Neither
This is,
neither the group of LPC holder nor encroacher. This is another unconnected person, Nara Loma, only being a clan member of the LPC holder. This
FIR that you are showing, page number 16.
Yes,
is
page number
lodged by the
16.
petitioner.
Page number 15. Page number 16 is FIR lodged by the LPC holder,
Not the
Nara
petitioner.
Meso, Nara Meso and others. And this is alleged that her allotted land has been encroached by someone else. And page number 18 is the second FIR. Page number 17 is second FIR.
Read the contents of 6.
Yes. Page number 17 is the Taiwan coffee. To the officer in charge, Cumin Police Station, District Papumpara, Arunachal Pradesh. FIR against unknown culprit for illegally trespass into my private allotted land and constructing dwelling house without my knowledge. Sir, it is to bring to your immediate notice that some unknown group of people is being constructed on my private land, that LPC plot situated at Upper Juni village fall within the LPC so and so that is so and so is being encroaching by constructing dwelling house by unknown person. It is requested to deploy police personnel. This is the past information lodged by the LPC holder alleging for unknown person. And
But the cause of action was 2012.
yes, now this
then?
is regarding the encroacher, land encroacher. And next page, page number 18 is second FIR. Here, same person naming the particular person who encroached the allotted land. Private copy is page number 19. To the officer in charge, police station Kimin, Papumpara District, Arunachal Pradesh, dated 2nd May 2025. Subject FIR against Sri Tadar Kamin, Tadar Logi, Licha Rajan, Ralo Kaku, Ngurang Rade, Chera Torun, Elais Tede, Sri Muti, Tadar Meku, Tawa Yaki, Sri Joram Beti. This FIR is lodged against this particular person. And this particular accused person filed a counter complaint against me. This
Here,
is-
petitioner is not there.
No. Uh,
Petitioner is not the accused.
no.
Then,
Page number, kindly peruse the page number 20. This is the FIR lodged by the accused petitioner, accused applicant. Earlier FIR, this say 8% is a accused, and here counter FIR, they are informant. So now I may be allowed to read the present FIR, page number 20.
It is 10%, so what?
Yes.
8%.
To the officer in charge, police station Kimin, Papum Para district, Arunachal Pradesh, FIR against Sri Nara Loma, this is me, for fraudulently helping to obtain 8 numbers of LPC and declare inter-state Assam Arunachal Pradesh boundary line upper Jumi village. Respected sir, with the undersigned villager of upper Jumi Kimin under Kimin Circle, District Papum Para, Arunachal Pradesh, submit this complaint letter is directed given by Circle Officer Kimin on 2nd 5/2005 for the forgery case against Sri Nara Loma, son of so and so, Upper Jumi so and so, for obtain fraudulent 8 numbers of land possession certificate to his family member.
For helping.
Yes. So present petitioner, neither a village authority nor a government official to helping them for obtaining LPC. The allegation helping the family member, those who obtain LPC, 8 numbers of LPC from the concerned authority. The LPC name is here given below. Family age alleged in FIR, number 1 Srimati Nara Meso, Srimati Nara Yap, Srimati Nara Yakam, and 8 number. This is LPC.
The Nara Meso is the complainant in the other
Earlier
FIR.
Yes.
So what is alleged is that this petitioner has been helping his family members
Yes.
to get this LPC fraudulently.
Exactly.
And the complainant is one of the family member of this person.
Yes.
And complainant has come against the 9 complainant.
And here
There are so many complainants and victims
another.
against this 9%.
Yes, yeah. Another, my lord, here, another as per the FIR, the circle officer came in, he directed the complaint to file FIR. But here, no such direction, written direction is annexed in the FIR.
And read the rest of the portion and also fraudulently declare the inter-Assam, interstate boundary lines. So.
The next para, and also fraudulently declare the inter-state boundary line of Assam or Arunachal Pradesh in LPC number so and so and so, or not so and so, which is totally violation of Honorable Supreme Court of India order. Assam Arunachal boundary issue sub judice. Arunachal government cannot declare boundary line without taking consent from the village of Upper Jumi. The LPC owner were ill intention to occupy the community land by making forgery of GPM seal and thumb impression in every LPC document. A written statement given by ex-GPM Upper Jumi Village Srimati Dukum Putu on 12/9/2014 in presence of EAC Kimin and were witnessed by her husband so and so and so. Whereas only 6 number of LPC certificate has been revoked as per DC order so and as enclosed. Remaining 2 numbers LPC is cancelled, but Srimati Nara Maso given written FIR complaint against Sri Tadar Kamin, who is informed Tadar Kamin, Tadar Sogi, Licha Rajan, Ralo Kaku, Ngurung Rade, Ceratadu, Tadar Metu, Taba Yakok, and Joram Betir. Whereas Srimati Nara Maso didn't mention their LPC document, so cannot.
I've gone.
Yes, this if we read this FIR, there is nothing material for prima facie case established against the accused person. As I have already submitted, the present petitioner is neither the village authority nor the government official to helping hand prudent manner to obtain the LPC. So here, as per the FIR, here indicate this is completely counter FIR in order to conceal the committed against the allotted land. So as per my understanding, what the law says, since this allegation is of offense committed in the year 2010, that is obtaining of LPC, and here LPC here if we read the LPC, my lord, here clearly this LPC is issued by the competent authority at the behest of the state government. So
But whether this is a case for quashing, I've understood your case that what had happened is these LPCs were acquired fraudulently. This is what the
Yes.
prima facie against these 8 persons,
Yes.
in favor of these 8 persons.
yes,
And this Nara Meso, and since it was taken up, since it was obtained fraudulently, some person must have gone to her land and then constructed something. That was in 2012. And then they have constructed some building. And this Nara Meso has filed an FIR against them.
yes.
And they, as a counter, had filed this FIR against the
yes,
person who had helped Nara Meso,
yes,
stated to have helped.
yes.
Right. But then the fact remains the land, whether it was allotted to them fraudulently or not, these are all matters of trial and all.
Yes. My lord, here we have one citation
There are so
Here,
many citations on
saying that unless the certificate issued by the competent authority, unless declared null and void, no such criminal proceeding can be initiated against that certificate, because this is alleging of fraudulent obtaining certificate.
No, that is there, unless the certificate is declared bad. But then this is a criminal proceeding where there are only allegations.
My lord, another ground here, this land cancellation complaint was submitted by the youth organization that particular village before the executive magistrate, that EAC came in, and that EAC came in, rejected their application and asked them to appeal before the competent authority. Then that association submit the representation before the deputy commissioner Papung Pardehe Yupia, who issued the LPC. Then Deputy Commissioner Yupia also didn't take entertain any kind of action.
Did not
Did not entertain. And then what happened later on? That association submit another representation before the Chief Secretary, Government of Arunachal Pradesh. Then Chief Secretary re-endorsed the matter to the Deputy Commissioner Yupia for passing appropriate order. Then that appropriate order, the Deputy Commissioner Yupia passed an order. So I'd like to peruse that order. Page number 54. Annexure 11.
54.
Yes.
The same land in question.
Yes. So here order say that
In exact
no application, no complaint regarding the cancellation of LPC to be entertained by the subordinate officer, subordinate executive magistrate of deputy commissioner. Here, let me read. Order dated 28 March 2018. In exercise of power conferred under separation of power from executive to judiciary from the single line administration in the past, neither DC, nor ADC, nor SDO, nor EAC, nor CO and outpost administrative officer have the authority to try and dispose of LPC issued by the DC or ADC as appropriate authority of the LPC, which is not only contrary but also violation economic law. Hence, for application or complaint against cancellation of LPC will not be entertained in the respective office until the directed by the competent authority of law for trial and disposal of the LPC cases.
The appellant to the competent court.
Yes. If they aggrieved against the LPC.
Yes, they have not entertained, they have not received those complaints.
Yes.
And they said go to the appropriate court since they
Yes.
do not have the power. But the fact remains the LPC,
Yes.
whether it was properly given to these persons or not, is disputed.
Yes, that is not disputed. That LPC, if we read the LPC issued by the competent authority, my lord, kindly peruse the page number 30 onward. This is the 8th LPC where mentioned in the
30?
FIR. Page number 31 onward. Page number 31. The LPC issued in the name of Sri Naramaso. Page number 32 is the type of coffee. Let me read the relevant for the second para. This certificate is issued on the basis of government direction communicated white letter number so and so dated so and so, directing all the deputy commissioners to issue LPC to the native people living along the entire state boundary of Assam Arunachal Pradesh. Here LPC is issued on the basis of direction issued from the state government. So that LPC 8 numbers LPC
It's
issued.
restricted to be fraud. It was obtained by fraudulent measures.
That
Now, whatever is there on record, I'm not deciding on this fact.
Yes.
Basis. I'm not deciding on this fact. So, as far as the allegation that it has been obtained fraudulently, it's there on the FIR, face of the FIR. And it also seen from the other records because certain authorities did not entertain. Then although you have shown that DC has given those LPC, but again there are allegations that it was fraudulently received. And there are proceedings for cancellation of these. So as a matter of fact, the issue is there. It's not that the issue is not there. It's not a case at all. If there is a case, when there is a case, how can quashing be done?
my lord, as by my understanding, since this LPC issued is still valid, the 8 number of LPC issued to the private person is still valid, and until and unless
It is
cancelled,
I understand.
no such criminal proceeding can be initiated against that related document. So moreover, this present petitioner is neither the LPC holder.
How can you say that no criminal proceeding can be instituted?
As per
FIR can be lodged under 154. And if it discloses a cognizable offense, it has to be registered.
if we go the FIR also, this is alleged offense committed in the year 2010.
That of course required delay.
And
But,
that complaint was decided. That complaint was decided by the EAC came in. That is already meta decided means res judicata.
No, 2012, these LPCs were issued, right? 2012?
The 2010.
No. 2012, they came and started building
Yeah,
structure.
2000 FIR LPC issued on 2012. Yes.
Is being encroached upon by constructing dwelling house.
My lord, here constructing dwelling house is FIR allegation, FIR lodged by this LPC holder against the private person who lodged counter FIR against me.
Yes, yes. So, anything more?
That's I pray the Deputy Honorable Court to issue notice upon the private respondent, and in the meantime, the investigation portion of the.
This is neither a case for stay nor quashing. What do you say?
Yes, it is clear from the report, in page 27. It is a statement given by one Dokum Photo ex-Gram Purchaser member that her seal and signature has been forged to obtain the LPC. There is a clear case of.
My name is format is not of me. So there may be something in issuing the LPC. So this is not a case for.
Forgery and use of forged document as a genuine document. It is there, clear case.
This is not a case for stay or quashing.
My lord, here FIR annexure also, here no such disclose the criminal material against, because only this FIR counter FIR is registered on a basis of one statement of former
And
GPM.
it is registered under what section?
468.
Yes,
468, 471. On and the FIR here said, as per direction of the circle officer. There is no such direction.
Yeah, that of course may not be there. But the fact remains, this is not a case for quashing or this thing. If you want me to issue notice, okay. Otherwise, I'm thinking to dispose of the matter.
Notice may be issued.
Otherwise, this matter needs to be disposed of, dismissed rather. You try in the charge framing, cognizance, everything. There are so many stages.
But let the other party may come, because this is the allegation.
Okay, right. Mahaki. They heard Mr.
T.
Swanson. And yes, G. Tado, the additional public prosecutor. This is a case, this is an application. filed under section 528 of BNSS 2023 by the petitioner, praying for quashing of the FIR number 7 of 2025, registered under section 468 and 471 of the IPC 1860. I'll not issue notice to respond number 1. Oh, Mr. Tado appears for respondent number 1. So no formal notice is required to be served upon him. Issue notice to respondent number 2.
2 to 12, no, 4 to,
Two, so many of them.
yes, 4 to 12. 4 to
All
12.
the complainants. Issue notice to, you will be appearing, Mr. Tado appears for 1, 2 and 3.
1, 2, 3.
1, 2, 3. And issue notice to respondent number 4 to 14,
12. 12.
4 to 12. Returnable within 3 weeks. The petitioner to take steps for service upon notice upon 3 to 12 or 4 to 12. 4 to 12 by registered post with AD or with usual process within 2 days from today.
High levelized.
May I, Lordship?
Yes.
Lordship, this is the civil revision petition against the cover decision passed by the Intervarious Customary Court.
Wakalatnama has been filed on behalf of the learned counsel and respondent. There is only sole respondent.
Yes, Lordship.
There is only one.
Yes.
You are.
Yes.
Lordship, my ground for revision is that the KEVA members who heard the case.
You have come against the KEBA decision.
Yes,
Against the decision of the affiliate
court.
authority.
KEBA Bango.
Yes, Bango, place customary court.
Bango means.
Yes.
Okay.
Lordship, there was a cover
Mm.
on between the animal, the domesticated animal dispute between the parties.
Mm.
Complaint was lodged before the village authority. Village authority passed a cover decision in favor of petitioner.
Mm.
Again, the sole
That means
respondent.
he owns those animals.
Yes.
In
We-
what
we have-
is the decision?
Decision, that disputed animal, Mithun, it was decided in his favor.
Mm.
Then again, I being aggrieved of the cover blaze authority decision.
You are also heard. before
Yes,
the
yes,
cover.
yes. Then I filed before the affiliate authority.
DC.
No lawsuit. Interplace customary court
Acha.
Interplace.
From the KEBA decision.
from the cover decision. Notice was issued, but he didn't appear. So it was passed. The
Ex parte.
affiliate authority decided to proceed ex parte and decision was passed in my favor. But Lordship, I fairly considered to the ground taken by the petitioner that under section 17 of this Arunachal Pradesh Civil Code Act, it's provided the governing authorities, place authorities, who were the member in first place authority, who decided the place authority, they must not sit in the affiliate court. But in present case, Lordship, the same authority
Oh,
who
they said-
decided the place cover decision,
Mm.
they again sit in the affiliate forum and decided in my favor.
No.
So his contention is it should be decided by press authority. So I do concede his grounds because there is a clear violation of section 17. So may I humbly also pray that Lordship may quash the affiliate order passed by the affiliate court and direction may be issued to the affiliate court to appoint a press Kabang member who were not decided in the first place Kabang decision to hear my appeal.
What do you say?
Yes, Lordship, that's my prayer only.
Hmm?
That's my prayer only.
That's your.
Yeah. Because section 17 has been violated.
Okay. So show me that the members were same even in the appellate authority.
Lordship, page number 19.
Show me the first KEBA decision.
Lordship is page number 19.
This was the original, the first.
Yes, Lordship.
First government, yes.
Page number 19, Lordship,
18 also there is something or,
that's the decision
18
and
is the block and
19 is the
Oh,
Kava
it's
members.
okay. There were 19 KEBA members.
members, yes. 20 is the translated code.
You also get white Mithun. Normally I've
Yes.
seen only black. White Mithun is also there.
Yes, Lord.
There's only one. Dispute is only one
Yes,
Mithun.
Only on one bit.
What is the petitioner's name? Jumken Damba. Actually, the Mithun was under the caretaker of Yi Ram
Ram.
Till.
Yes,
And Sri Redu Doji had lost the Mithun. Redu Doji is the owner of the Mithun.
Yes.
Seeing the physical appearance and features of Mithun, followed by a hearing from available the house meeting members decide the Mithun belongs to Jumken,
Okay.
that is the petitioner,
yes, Lordship.
and caretaker Yi Riram. So first KEBA decision was
In my favor.
given in favor of him,
Petitioner.
Petitioner.
Jumken.
Yes.
You are for Jumken.
Yes,
Okay. And KEBA members are only these three, Jumken, Dambak, Rido, etc. They are the participants.
They are the owners, yes.
They are the
Keva owners.
complainants and all of
Yes, yes, Lord.
Lordship, Kava members are in page number 19 and
19, there are 19 KEBA members.
yes.
Yes.
And then show me the
And in
appellate
appellate,
inter-village.
58, yes. 58, Lord. Sir. 5 copies.
58, what is 26? Mithun dispute case judgment.
These are the deliberation of the all speakers.
Okay.
Their statement during cover proceeding has been recorded.
Then 58.
yes,
It
Lordship.
is the government members before the affiliate forum.
58. They are same.
Yes, Lordship.
There were 19 and now there are 21.
Lordship, just one only is different, one edit.
Two members are different. 1 to 19 were there before the original KEBA, and there are 21 in the appellate. What is the decision of the appellate? Where is that? Which was given in his favor? Page 57.
59.
59. 59 is in vernacular. Okay, 64.
64.
On the second cover, the appellate authority, you did not appear.
No,
Oh,
I
he did
I
not
did
appear.
not have. It
He
was,
did not.
yes.
Initially, you did not appear.
No, we both appeared before the blessed authority.
The first one.
Yes, first one.
Mm.
But my contention was not fairly considered, so I filed a appeal.
Ah. Conflict to- Otherwise, the president and secretary were different or what? on the head Gaubura and Gaubura Pushi Bango area.
Yes.
Minjum Bagra. Minjum Bagra was there in earlier thing also. Minjum Bagra is not there. Mojum Bagra is there. And Beke Angu is there as secretary to look after the matter.
Yes, yes.
I cannot say all the members. I think most of the
Yeah,
members.
most of them.
Maximum.
Not hun-
Most
not-
of the
not-
members.
Not all the members.
Right. I heard Mr. Okay. So for the petitioner.
Yes.
This is a British criminal petition. No.
Civil
CRP, yeah. So and so for the petitioner and so for the response. K. Lawlen for respondent.
Yes.
This petition is filed under Article 227 of the Constitution of India for setting aside the decision dated 4/1/2024 passed by the Inter-Village
Yeah.
Territorial Customary Court, Pushi Bango,
Yes.
Higi Bagra is what? That's another name. Pushi Bango Higi Bagra Keba decision by which the decision of the village authority of Angu village has been reversed and direction was and it was directed to hand over the Mithun in dispute to the respondent. The fact of the case is that on 4th of October 2024,
Yes.
the Keba at the Gaupura, the entire house, this is called as what? The
Less level cover.
village level Keba, village level authorities, right?
Yes.
Village level authorities had decided a dispute over ownership of a Mithun between the respondent, between the petitioner and the respondent. The said village authority, the said village meeting was attended by 21 numbers of members who were head Gaumburas as well as Gaumburas of the respective village. And it was decided in the said meeting that the Mithun under dispute should be handed over to the petitioner, that is namely Jumken Kamdak, and the caretaker of the Mithun, namely Sri Riri Yigi, YI, Riram. That meeting was attended by both the petitioners and the respondent. Full stop. However, the respondent, not being satisfied with the decision, since he stated his contention was not properly considered, he filed an appeal before the Inter-Village Territorial Customary Court,
Yes.
Pushibango, on 4th of January. Oh, no. He filed an appeal before the court, that customary court, challenging the order dated
4/1.
4
4/10.
October 4/10, 2024. 4. The village, the inter-village customary court issued orders on 23rd of October 2024 to hear the matter of ownership of the Mithun on 30th of October 2024. However, on the said day, the petitioner did not attend the village court meeting, village court hearing. Full stop. On 5th of November 2024, the head Gaubura and the Gauburas of Pushibango appointed another head Gaubura as president, appointed one, namely Minzom Bagra as president, and Shri Beke Angu as secretary to look after the matter. Full stop. Under the and thereafter, full stop. Thereafter, on 19th of November 2024, an order was issued to the petitioner and the caretaker of the said Mithun to appear before them to discuss the matter about the ownership of the Mithun. However, the petitioner again did not attend the meeting. For the third time, that is on 21st of December 2024, a date was fixed for hearing on 4th of January 2025. The petitioner again did not appear on that day. Since the petitioner did not appear for so many times,
3 consecutive times.
3 consecutive
Yes.
times, the community court, the inter-village territory, the inter-village customary court proceeded to pronounce the decision ex parte. And in that decision, the court after considering the merit of the case, after considering the evidences, decided that the Mithun in question belongs to the respondent? By holding inter alia that the decision of 4th of October 2024 was incorrect? And the court, as such, returned the Mithun to respondent number, to the respondent
Yes.
for ownership. The counsel appearing for the petitioner, Mr. So-and-so, submitted before this court that the members attending the meeting in the original village court, that most of the members who attended the meeting of the village court were the same members who attended the inter-village territorial customary court. Which according to the learned counsel of the petitioner is incorrect. Where is the provision of the
Yes. Section 17, clause 2.
the on the K. Lolen appearing for the respondent fairly had submitted that the members were the same in both the committees. Most of the members were same in both the committees, and that the same is not
Permissible.
accordance with the law. The same is not accordance with the law. He placed section 670 of the Arunachal Pradesh Civil Courts Act 2021 wherein it is provided in subsection 2 that open inverted comma, no judicial officer or authority of customary court shall try any appeal against any decree or order passed by him/her in any other capacity. As such, a prayer is made before this court. Then the impugn order may be quashed and the parties and that the aggrieved party may refer the appeal afresh before the appellate authority.
Lordship, may I have Lordship? Lordship, I'm praying for a direction to the president to appoint a fresh government members and to hard member because my appeal is pending here. So direction may be issued him
To the president of the
yes,
Inter-
inter-place customary.
to form a new committee.
Yes, fresh members, government members.
As such, a prayer is made to quash so and so there, and a direction to the president and for a direction to the president of inter-village territorial customary court to appoint fresh members who were not there in the committee of the village meeting,
Yes.
who were not there in the committee of the village, Keba,
Keba decision dated 4/10/2024.
who were not there in the committee
Please,
What-
Keba decision.
of the Keba decision dated 4th of
4/10.
October 2024.
Yes, Lordship.
I've heard the counsels and have gone through the records. It is noticed from the chart of members annexed with the petition as annexure 2, as well as a chart in connection with the village meeting held on 4th of October 2024 and the members given in the chart, members of the committee given in the chart of the comprising of the committee of inter-village territorial customary court that most of the members are same. Full stop. It is clear from section 17 of the Arunachal Pradesh Civil Courts Act that the authority of the customary court shall be different. The authority of the customary court shall be different from the authority who passes an order in the village courts. As such, this court finds the impugn order dated 4th of January 2025 as unsustainable and the same is quashed. This court further directs that the president of the Inter-Village Territorial Customary Court, Kushi Bango, may constitute the committee comprising of other members not included in the committee of members of the village committee. Within a period of 2 months,
2 months.
within a period of 2 months from the date of the receipt of the order.
Lordship, small direction may be issued to both the parties. If that is fixed by the president, both should appear. Because
That's what the president to do, he will summon both the parties. Okay? Because the prayer is only this. Both parties should appear, he will.
on that fixed by the president, because otherwise again there may be some lingering because not appearing on that fixed, then another date will be, it will be difficult to.
That is for the president to tackle. What is the prayer here? Let me see again. Only for quashing and this stage. That will do. It is for the president to do. The petition is disposed of.
Okay.
With the above directions.
Deeply obliged.
May please, Your Lordship. Item number 10, miss.
You are there for the petitioner.
Yes, sir. So I am on behalf of the 482 application. I am for the petitioner. Already, with the respect, my lord, I am on online because I am straight from Guwahati. My lordship, kindly see, these application already had 2 times. And last occasion already passed an order. And today they fixed for CD and the case diary from the lower court below. And subsequently,
Case diary and the records.
yes, Lordship.
Okay.
And already last occasion, already Honorable Court heard my matter, and the allegation is that some misappropriate of money from my side, and subsequently already I am clarified before the Honorable Court. Kindly see the FIR page number 15, ma'am.
The CD is available today?
Yes, Your Lordship.
Even the case record means what?
Your Lordship, there was an NBW issued by the,
Okay, then we will hear it too. It's already one now.
No problem, madam.
We'll hear it too.
Much obliged. Highly obliged. Good afternoon, ma'am. May I please, Your Lordship? 482 application item number item 10. Hello. I can't hear. Lordship, I can't hear. I can't hear. My item number 10. Lordship, I can't hear you. I am sorry, Lord. Wait for some time, Lord.
Let the other matter be taken.
Yes, yes, I have here now. I am
You
here
can
now.
hear, you can
Yeah, I
hear
can
now?
hear you. Yes, Lordship.
Okay.
I am
Yes.
sorry, Lord.
Hmm.
My Lord, kindly see, FIR was lost 6/12/2019. Since 2019, I am surprisingly shocked when the police visited my house on last month, 26th of May 2025. Before that, I don't know anything what is going on. As per allegation, I am not all the employee. I am just employee. I am not the executive, sales executive of the said dealer. I am the consultant of the said dealer. And kindly see in FIR page number 15.
You were not aware of the case
Yes,
at
Lordship.
all?
No, I'm knows about the only because of that 26th of May when police visited my house and received the notice to me. Immediately I am talking, and next day 27 I'm immediately come from Guwahati to Arunachal for obtain the certified copy. Then I know there some allegation are made against me. And FIR was lost in 2019, now 2025. No any received, no any phone call. How can I know that lordship there some allegation are made against me?
When did you come to know about the about the FIR?
FIR when the police visited my house, I am
When?
residing 6th of May 2025.
This year. Okay.
Yeah, this year. And my lord, kindly see, after receiving the copy, immediately I am come from the Guwahati to Arunachal for obtain the certified copy. I collect the certified copy on 27th of May. Then we know the facts where the allegations are made against me and totally falsely implicated against my because I am still question is my lord I am abstanding or not because at that time when I am working at the dealer my work is I am just collected the report to submit the directly to the company not any financial letter.
Show me the FIR. Show me the
FIR page number 15 my lord kindly see.
Yes.
May I read?
Yes.
This affair is lost before the authority agent Sri Anup Barua, who has seated me and some of the customer. He is serving sales executive in Itaford Ford dealer. He has committed criminal breach of trust, Ford cheating by forging, the using the dealer money received without my consent and misappropriating the money of the company. Hence, the authority of this concern may initiate necessary criminal proceeding against the aforesaid person by immediately determining the person mentioning above the book under relevant section of code. It is informed you on 2/12/2019 at around 9 a.m. One of my staff furnished a copy with a money receipt of Itaport dealer amounting rupees of 50,000 and rupees 17 lakhs respectively. Upon inquiring about the matter, it was found that Sri Anup Barua has issued the company's money receipt book and uses in his concealing manner for personal gain. The company's money received from is kept with the accountant, but how it can in his hand, it's not known. Apart from that, one person also made a complaint that he had paid 4 lakhs in the personal account of Anup Barua and obtaining for car eco sports, but after transferring the amount, he fed away. There is no further report in this concern. He is misusing the company's name and my reputation. These are the my lord allegations. And as per allegation, the Mirzuli PS 95 already registered. And subsequently, when the police visited my house, then I know that some allegations are made against me. And very next day, 27th of May, I come from the Arunachal for obtaining the certified copy. Then no, already 7th of March, 7th of January 2020, NVW issued against me. Kindly see the page number, my lord, 17 in my petition. 17, the 7th of January 2020, Honorable CJM Court passed the NBW against me. My lord, FIR was lost in 2019. The NBW issued on 2020. Now 2025. How can I know that some allegations are made by against me and some NBW issue against me? When the police visited my house, immediately I come home to the certificate copy, then knows the actual fact. Now, my lord.
What is the stage like this order of 7th of January 2020?
Yes,
This
sir.
was also not known to you.
Definitely not. I don't know anything because my lord.
Then let me go through this order once.
Yes,
For
sir.
issuance of NBW against so and so, your petitioner.
Yes, sir.
Let's say a written complaint for someone about Anu who is working has treated him, some of the customers, and misappropriated or received a fire during the course of the witness and they were examined under statements. It reveals that Anu Bola has received so and so on various payment from being delivered car from so and so by using money receipt or not after receiving this NBW, this again is speaking of another FIR, I think.
Yes,
The
my lord,
FIR, the allegation that is there in the order dated 7/1
Yes,
is
sir.
in respect of another vehicle.
Yes,
See,
that's the main.
that was not in respect of the present FIR.
Yes, lordship. Main question is that, my lord, who lost the
Let me finish and escape from without any intimation, hence the prayer for issuance of so and so. Okay, NBW again, sir. So that NBWA, you didn't know it was issued in the year 2020.
I don't know, my lord, because kindly see, I am stayed in Guwahati, in the middle of Guwahati at Gitanagar. And Gitanagar, from my house to Gitanagar PS, only 100 meters. When the police is visited, then I know the facts. And my lord, if allegation is, I know if some allegation is made against me, then definitely I am file a bail application in the year of 2023, 24, 22. But I don't know anything. When the police visited, I come to know that. And my lord, kindly knows the facts. When the FIR was lost, they categorically stated, kindly see the FIR in para number 2 in the middle part. My lord, kindly see. In the FIR, the informant categorically stated the company money received from the CAP with the accountant, but how it can in his own, they don't know. My lord, I am as an employee, I am employee of the dealer. My work is to collect the report to submit the company, not the financial, because financial matter are looked by the accounts department. And my lord, kindly see, somebody booked a car. It's a huge amount. It's a definitely GST bill, because how can it possible I collect the money, not deposit the dealer? Because I don't know it. All the fabricated allegation against me, my lord. And I'm just want to say,
Those will be seen during investigation.
Yes,
Now,
my
let
lord.
me hear from Ms. Ginny as to what happened with the investigation.
We have in fact made a prayer before the learned magistrate for declaring him as a offender, your lordship. Proclamation offender for an order. It is yet to be received, your lordship. Even otherwise, your lordship, in the CD, it has been reflected that NBW was issued, and then a raid was made to his house, given in the address of Guwahati, your lordship. He was not found there, your lordship. A repeated request was made. Thereafter, investigation officer was also changed, your lordship. And thereafter, once the investigation officer was changed, he had made a prayer before the executing magistrate for declaring him as a proclaimed offender, your lordship, which has not been done till date, your lordship, because the TCR has also
What
come
do you
in.
say on his submission that he did not even know at all?
No, there is a statement of all the witnesses, your lordship. One is also a sales manager who clearly states that he was the one who more particular dealt with the booking of a car with regard to Endeavor car, your lordship. Now, if a booking is made, your lordship is well aware that this money goes to the account of the dealers, your lordship. There is a
Absolutely
dealer.
not, my lord.
There is a dealer account which normally goes, your lordship. She has also stated, even the complainant has stated, and even the proprietor of the car dealer has stated that it was handed over to him, your lordship. And thereafter, after the FIR was filed, your lordship, he has absconded, because prior to the FIR was filed, a legal notice was sent from the complainant side to the dealer, your lordship. That's when the issue came into the notice, your lordship, and subsequently the FIR was filed, your lordship. Even otherwise, your lordship,
As far as NBW is concerned, there you see the vehicle is different. This is Endeavor car,
Yes,
for
yes,
which he had
lordship.
received 17 lakhs 50,000
yes, your lordship.
only as booking advance payment.
Yes, your lordship.
And whereas in this FIR, they speak of something else, Eco Sport.
Yes,
And
lordship.
one person has complained that he has paid 4 lakhs.
Yes,
So
lordship.
there are 2 FIRs, it seems.
Yes, your lordship.
And my
This-
lord,
This
Wait, let her finish. I'll come back to you.
This NBW there might have been some, because the complainant is Koda Raja, your lordship.
Complainant is the same. Khoda Raja, yes.
Same, your lordship. He is the dealer principal of Ita Ford dealer, your lordship. In the if your lordship will see, then come to page number 16, your lordship.
And the date is also same. 6/12 a written
Yes,
complaint was
yes,
received.
yes, your lordship. Your lordship, if come to page number 16, your lordship.
16 of the petition.
Yes, your lordship.
Yes.
If I may read from the second paragraph, your lordship. It is to inform you that on 2/12/2019 at around 9 a.m., one of my staff furnished a copy with a money receipt of Ita Ford dealer amounting to 50,000 and rupees 17 lakhs respectively. Upon inquiry about the matter, it was found that Sri Anup Barua has used the company's money receipt book and used is a counseling manner for personal debt. Company money receipt form is kept with the accountant, but now it came in his hand is not known. Apart from that, one person also made complaint that he had
Apart
paid.
from that.
Is there 2 complaints? For 40,000 in personal account of Anup Bora to obtain a car Eco Sport, but after transferring the amount, he fled away. There is no further report in this context. He is,
Judge.
so there, yes.
Hmm.
Your lordship will see that the complaint was made by the dealer, your lordship, not by the people who had booked the car, your lordship. This is a dealer that there were two issues. One was with regard to one of the complaint booking of 17 lakhs for an endeavor, your lordship. Another is by one person for booking of a car or EcoSport, your lordship. Now, your lordship is also well aware that NBW was issued. He was also, there were also raid made in the house. There is no question that he won't be aware of the about the FIR, your lordship. Also, your lordship, since he had not even challenged the for recalling of the NBW, your lordship, if this anticipatory bail will be maintainable per se, your lordship. I just have a recent judgment, your lordship, where the apex court has also dealt with issuance of non-bailable warrant and the subsequent application of bail before the honorable.
See, Mr.
Arkanas,
Yes.
my
Now-
lord.
Yes, now here we have seen that
Yes.
this FIR was lodged in 2019,
Yes, okay.
and then see, and it involves lot of money of the customers.
Yes, okay.
NBW was issued against you,
Yes,
but
okay.
then you were not found. I mean, you have annexed only one order here.
My lord, when I got the certified copy, only collect only NVW order and the FIR copy. And my learned friend already submitted, I given a reply. That's my lord. As per the allegation of the FIR, the dealer already lost the FIR against me, but no any persons who are given me 17 lakhs, who give me the 4 lakhs, nothing mentioned in that FIR.
Right, those may not
Yes.
be there.
Yes, and my lord, kindly
FIR will
see.
not include everything.
Yes, yes, my lord,
But,
kindly see. If I am abstanding, then
Hmm.
my lord, why I am leaving the job till the month of December in 2019? Because
Hmm.
when the COVID situation is coming, Honorable Court knows very well, entire world will be destroyed. And I am FIR is lost in 6 on 12, but still I am working on that dealer. When in the month of December, because I am reported repeatedly to the company, I am leave the job only because of the financial condition of the company, Ford company, entire all over India, they left away. There is no any position to give the salary to me also.
That took place before the investigating
Yes,
officer.
yes.
What
So-
happened after this 7/1/2020?
Yes, 7/1/20, I don't know
7/1/2020, your
Any
lordship.
orders?
There is no order, your lordship. We had made a raid. Our
You said
CD
that we had-
reflects of the raid made at his house. We were also a WTV message was sent to the concerned police jurisdictional police station, your lordship. Subsequently, your lordship, we had made a prayer before the magistrate. That's the only update, your lord, for declaring him as a proclaimed offender, your lordship.
And what
Madam,
about statements by other witnesses?
Yes, your lordship. I have flagged it mark as a pink flag mark, your lordship.
This is by
But this is by the owner of the proprietor of the car dealer, your lordship.
Hodaraja.
Yes.
is the informant.
And any other witnesses?
Yes, your lordship, the complainant, the person who has booked the endeavor car, your lordship.
He has also stated about him.
Yes, and 9 is the sales manager, another sales manager, your lordship, which she clearly states that when she wanted to deal with this particular customer who was buying the endeavor, your lordship, he has clearly objected, stating that let me deal with this. Since both of them were sale executives, your lordship. So when this client came, your lordship, she was supposed to deal with this client. However, he objected to that, saying that all the endeavors cars are to be managed by me, and therefore even she reflects that all the money that was given in advance was collected by him, your lordship. The fact remains that even though the receipt was given in the name of the dealer, your lordship, the money which the receipt he had given, your lordship, and the money the receipt was never deposited in the dealer's account, your lordship. That's the main issue, your lordship.
See,
My
there
lord.
are materials against you in the CD also, and
My lord,
the case has been pending for long,
yes,
and
lordship.
NBW is issued.
Yes, lordship.
This is not a fit case for anticipatory bail.
My lord, kindly see, my lord. If I am arrested, I can anytime am arrested because I am staying in a businessman, my family members, my 2 children. And if I am behind the bar, then my whole family will be destroyed. I am ready to full cooperate, my lord. I am
I'll have
ready
to
to full cooperate.
No,
I am
no,
ready
I'll
to full
have-
cooperate.
No, you have not been cooperating. It's not possible that you will not know about this
No,
case for
my
so
lord.
many years.
My lord, kindly see, my lord. If FIR registered in 2009, for a moment, my lord, it's my humble prayer, my lord, for the ends of justice, my lord. Kindly see, if FIR is lost 2019, NBW is 2020. No any message, no any phone call. How can I know that some allegation is made in Arunachal? Because I left, I'm left the job in the year of 2020 when COVID started. Then I now permanently reside in Guwahati at Gitanagar. Gitanagar police station and my house is only 100 meters. It's a neighboring police station. So how can it possible I am absconding? And I
Where
don't know
is
anything.
this,
What is going on?
Where is this dealership? Where it is in Arunachal, right?
Yes, it's
Authorized
Arunachal.
dealer in Naharlagun.
Naharlagun. Your Lordship.
Naharlagun. And I'm at that time working as a consultant, not the sales executive. My work is to collect the report to submit the company, not the financial matter. Because who book the car, who deposit the money, I don't know anything. My lord, if I am not supported to anybody, no any phone call, no any receive SMS, then how can I know that there's some allegation or notice to be issued? And my lord, most important thing is that I am reside in Arunachal till I am December 2020. But police knows my addresses. And after lodging the FIR, they don't know connect me. And when I left Arunachal, now permanently I am staying in Guwahati as a businessman. My lord, if I am arrested and police when visited my definitely I am in outside in Guwahati. And my family member informed me that some police are come to my house. And that's
How did you come to know? You said police visited your place.
26th of May 2025, my lord, when police visited my house. And immediately 27, kindly see my certificate copy dated. I come from Arunachal for obtain the certificate copy. Kindly see the date of the certificate copy, 27th of May. Then I am afraid if I am arrested, my whole family will be destroyed. Any condition, my lord,
Where is that certified copy you said you have received on 27?
kindly see, my lord, it's dated on, kindly see the page number 17, my lord. Page number 17, the report, annexer 2. It's collected from 27th of May, last part, my lord. 26th May, they are visited my house and immediately next day I am come to the Arunachal. Then I am shocked. There's some allegations are made against me in the year of 2019. And NBW issue, my lord, it's a simple question. If some NBW issued against me, then definitely I come for recall. Definitely I come file a petition for anticipatory bail. If I am not receiving any phone call, any notice from the police, then how can I know that some allegation are? Main important thing is that, my lord, till 2019 to till 26th of May, police not submitting the charge sheet against me. They are totally not is capable to collect any evidence against me.
Your Lordship, I'll just come to that, Your Lordship. Your Lordship is well aware that this FIR was not filed by any of the customers, Your Lordship. It was filed by the proprietor, Your Lordship. If he was still in service, would it not be that proprietor would deal with his own executive members, Your Lordship? In the FIR, it's clearly stated that he has gone to Guwahati, Your Lordship. Thereafter, he never came back. I have just placed a citation, Your Lordship, where I just...
Where is it written that he has gone to Guwahati and will never come back?
Your Lordship will see...
At present,
he is in Guwahati, Your Lordship.
Gitanagar?
I'll just come to that.
At present, he is in Guwahati.
Yes.
That means
Thereafter, he went. Yes. Thereafter, if he would have been there in the working as a member of the car dealer, Your Lordship, would this FIR be filed, Your Lordship, even before, prior to not intimating him, Your Lordship? I'll just come to a citation, small citation, Your Lordship. It's of
With due respect, my lord.
2024, Your Lordship.
Wait, I'll come back to you. What? Which paragraph?
Paragraph, Your Lordship, paragraph 16 and 17 deals with issuance of non-bailable warrant and the procedure, Your Lordship. I won't go through that, Your Lordship. If Your Lordship come to page number 9, paragraph 24, Your Lordship. If I may read, Your Lordship. We have already held that the power to grant anticipatory bail is an extraordinary power. Though in many cases it was held that bail is said to be a rule, it cannot by any stretch of imagination be said that anticipatory bail is a rule. It cannot be the rule, and the question of its grant should be left to the cautious and judicial discretion by the court depending on the facts and circumstances of each case. While called upon to exercise the power, the court concerned has to be very cautious, as the grant of interim protection or protection to the accused in serious cases may lead to miscarriage of justice and may hamper the investigation to a great extent, as it may sometimes lead to tampering or destruction of the evidence. We shall not be understood to have held that the court shall not pass an interim protection pending consideration of such application, as the section is destined to safeguard the freedom of an individual against unwarranted arrest and we say that such orders shall be passed in eminently fit cases. Your Lordship may note this paragraph, Your Lordship. At any rate, when warrant of arrest or proclamation is issued, the applicant is not entitled to invoke the extraordinary power. Certainly, this will not deprive the power of the court to grant pre-arrest bail in extreme exceptional cases in the interest of justice, but then persons cautiously defying orders and keeps absconding is not entitled to such grant, Your Lordship. Now, if in such cases, Your Lordship, if the case at this, the present case, if the matter is in extreme exceptional cases for the interest of
One
justice.
thing is that he had shown, of course, it should not be entertained if warrant and all those are issued.
Yes, Your Lordship.
But again, in exceptional cases, now he has shown in the order,
Yes, Your Lordship.
it's written that he has come to know only on 27/5/25
Yes,
because he has obtained the certified copy
Yes, Your
of
Lordship.
this.
Yes, Your Lordship.
Yes, Lordship.
This is 23 or 25?
25, Your Lordship.
25.
Yes.
So in that case, he might not know also.
My humble submission before this court is that this is a case of that he not knowing about the FIR more so when he's working in the same company. After this incident, if he had come and joined the company and he was still working, there would not have been any action with regard to issuance of NBW, Your Lordship.
Where are you working now? After this, whether you are still working?
Yes, yes,
as
my
a-
lord. That's the main question. I give the reply, my lord, to the learned friend question. I am leave FIR law 6/12/2019, but I leave the job in the month of December 2020. Still, I am working when they lost the FIR. And my lord, I am leaving the job only because of Honorable Court knows very well. At that time, the fourth company is not pursuing in India because they are financially or some technical, they are left away. Not only Itanagar, entire all over India, they are left away. They are not given by the salary. They are not given the salary to the other employee. And that's the main issue. They are lost the FIR. And I am
That I
subsequently
know.
leave my job.
That I know, but then you left your job in 2020.
Yes, well, I am in the year of 2020. I left from Arunachal to Guwahati because I have the family member. I am the only young bread butter in my family. I have my family consisting.
After this FIR was launched, you were still working as a
Definitely, I am
sales
working. No, I am
and you
not
did
sales
not
executive.
know. And
No,
you
my
did
lord.
not know.
No, my lord. My question, my prayer is, I am still working on that dealer as a consultant, not sales executive. I am
Yes,
a-
whatever, at
Yes,
whatever string. But then
Yes,
you
Lord.
did not know about the FIR when you were working there.
Definitely, I don't know anything because I am still working in the month of December 2020. FIR is lost in 6th of 12, but I left the job in the last part of December. But they
So
not
for
informed
the
me.
for the 1 year, long 1 year, you did not know about this FIR at all.
Not. I don't know. They are nothing informed me, my lord. Our
This is
police
little unusual when somebody still works.
and my lord, most important thing is that when I am working in that dealer, I am residing in Arunachal in the middle part, Naharlagun, as a rented house. The dealer, manager of the dealer, and the other employer knows my addresses. Police not search me in Arunachal. But when I am come back to the Guwahati, because how can I survive my family, my lord? My consisting my oldest parents.
Only thing that is troubling me is that certified copy of both the FIR and the order were received on 27/5/25.
No, received in the sense they had applied for, Your Lordship. Now they are applying because Your Lordship will see that prior to issuance of an NBW, Your Lordship, the IO has to satisfy the magistrate that we have tried, but this person is absconding. Now, if Your Lordship will see that Nirjuli police station and Ita Fort, where the car dealer is, Your Lordship, it's not even 200 to 300 meters away, Your Lordship. Now, if that is the situation, that he was still working during the filing of the FIR, would his own proprietor not tell him about the same? Would the police, who is just 200 to 300 meters away, would not come
lord.
after them? And the
One
NBW
thing
was
is that let me hear the proprietor. Right.
My lord,
He is
my
not
lord.
made a party.
He's not made a party, Your Lordship.
You make complainant a party, then only I can decide on this issue.
My lord, I have one more prayer before the honorable court. Any cost of I can may be protected because my family member will be destroyed. And my lord, kindly see, I have mentioning in para number 7 in page number 5. Kindly see para number 7. 7th of January 2020, Honorable CJM Court passed an NBW against me. But my lord, police was failure to submit their charge sheet. Kindly see, the lower court passed an order in 2nd of May 2025. Why they are not filing the charge sheet and which date is fixed on 21st of July in 2025?
That is their concern, that they will do
Yes,
it.
yes. So
Whenever they finish the
my
investigation.
prayer is, my lord.
But what I'll do today is that I'll make the dealer a party, the complainant. Then only we will come to know whether you were apprised of. And your interim will be considered on that day.
My lord, kindly see. I have
I have been kind enough, don't worry.
My
But then
lord,
I will.
with
But
due
I
respect, my
will.
lord. With due respect, my lord. Already 2 days, already I am appeared 6th of 12 and 23rd. Already Honorable Court heard my matter. Any point of time I may be arrested, my lord. If I am arrested, then all
Because
now, my
so,
lord, police. Now, my lord,
the
police knows
honorable-
my address.
It's okay. Honorable Apex Court has said wherever there is an MBW,
Yes.
only in exceptional circumstances AB should be allowed. I can consider your exceptional circumstance that you were not known. You did not know about this. But let me hear the dealer, the complainant, and then I'll decide.
I respect
You
my
take
lord.
you take a short date and then I'll
My
decide
lord,
on
my
this.
lord, my lord, my lord, my simple prayer is that, my lord, till next date might be protected. When they are come, everything is crystal clear. So my man, I am afraid to the police anytime they are may visited my house because my child is now they are minor. They are on 26th of May. They are afraid when police come to my house. Well, I don't know anything. I got the certificate to be 20.
It's okay, I understand. I've understood your case, so I will
Kindly
I'll
protect me,
issue
my
that.
lord. Kindly protect my lord. My
Because
humble prayer, my lord. In the interest of justice, my for my children, my lord. Kindly protect me, my lord.
had it been
Next day.
had it
next
been
date.
not so many years, I would have understood. But it is so many years,
Yes.
and NVW issued,
That's the
nothing
main.
could be done.
My lord, I respect to the honorable court order.
Heard Mr. Nath,
RK Nath.
R.K. Nath for the petitioner and Ms. T. Ginny, the additional public prosecutor. This is an application
482, my lord.
under 482 of the BNSS, praying for grant of pre-arrest bail to the petitioner, namely Shri Anup Borua, in connection with New Jubilee PS case number 95 of 2019, registered under section 406/408/419/420 and /427 of the IPC. The prosecution case, as is revealed from the FIR, is that the dealer of Ford dealer, Ford
Yes,
Ford dealer, Ford dealer, Model Village, Naharlagun, and an authorized dealer for Ford. Model Village, Naharlagun, filed an FIR against the petitioner, alleging inter alia that the petitioner, who was working as a sales executive in Ford dealer, had committed breach of trust, fraud, and cheating by forging and using the dealer's money receipt without the dealer's consent and misappropriated money of the company. It is stated that on FIR dated 6/12/2019. It was further stated in the said FIR that on 2/12/2019 at around 9 a.m., one of the staff furnished the complainant a copy with a money receipt of the dealer amounting to rupees 50,000 and rupees 17,000 lakhs respectively. Full stop. Upon receipt of the same, the dealer inquired and found that the petitioner had used the company's money receipt and had money receipt. Okay, I had what? I had issued companies money receipt. And that the company is unaware as to how the money receipt went to his hands when the same should be with the accountant. It is also stated that the petitioner had taken 4 lakhs of rupees from a customer to obtain a car on behalf of the said customer. But after getting the money, he fled. This FIR was registered on 6/12/2019. And 2019 by the police. The police carried on the investigation and recorded the statement of the witnesses on 19 only, 6/12, same day. 8/12. Recorded the statements of the witnesses in the month of December 2019 itself. What is the latest listing?
Your Lordship, the last one with the green flag mark, Your Lordship. The another sets.
Actually, here only I can see that prayer for issue of proclaimed offender.
Yes, Your Lordship.
It is noticed from the stipulation made in the case diary on. Oh, no, before that. Don't cut that, but before that, you write. Thereafter, on 7/1/2020. The investigating officer of the case had prayed before the court of CJM Capital Complex at UPR for issuance of NBW against the petitioner. Full stop. Thereafter, on 27/1, thereafter, the police continued the investigation. Before that, however, the said NBW could not be executed. Oh, prayed, no? I said prayed for
Yes,
issuance
yes,
of the NBW, and the said court directed the IO directed for issuance of the NBW against the petitioner by order dated 7/1/2020. Thereafter, the police made many endeavors to execute the NBW issued against the petitioner. This is on 7/1. After 7/1/2020. After 7/1/2020, yes, not much
During the
Except-
COVID
that is
pandemic
COVID
time. Subsequently, even the IO was changed and then the NBW was issued, Your Lordship. Subsequently, the IO had also changed in this matter, Your Lordship. The new investigation officer had then prayed.
Thereafter, due to the pandemic, that is COVID-19, that was enveloping the world, the investigation could not proceed much. And in the meantime, the investigating officer was also changed. Thereafter, on 27/1/2025, a prayer was made before the CJM UPR for declaring the petitioner as a proclaimed offender. The counsel, Mr. Nath, the counsel appearing for the petitioner submits that he was totally unaware of the FIR as well as the order dated
7/1. 7/1.
as well as the order dated 7/1/2025, by which the NBW was issued.
2020, Your Lordship.
2020.
2020.
7/1/2020.
7/1/2020.
Oh, 7/1/2020. He was unaware of both. He further states that he came to know about the same only when the police went to his house at Guwahati on
26th of May.
26th of May 2025.
Yes.
And that immediately on 27th of May 2025, he came to Arunachal Pradesh. He came to the state of Arunachal Pradesh and collected the certified copy of both the FIR as well as the order dated 7/1/2020. He further stated that he was simply a sales executive. He further
my lord.
stated that
Counsel,
he was serving as a sales executive in Itaford Company in the year 2019, and he had no connection with the accounts department, which deals with the sale of the vehicles.
yes, sir.
As such, he has no role in taking the money as alleged in the FIR.
Yes, Lordship.
Para Ms. T. Ginny, however, stated that the petitioner was working as sales executive in the said company even after the FIR was lodged. And there was no occasion for him not to know about the FIR in question. She stated that the petitioner absconded himself all these years and no bail should be absconded so many years, for which both for which the NBWA was issued, and steps were on to declare him as a proclaimed offender. As such, she prays that no bail should be granted to him. Since police has reached his place,
Yes, Your Lordship.
he knows his residence.
Yes, Your Lordship.
Yes, Lordship.
And it is also seen that he has obtained the certified copy.
Yes, Your Lordship.
Yes, Lordship.
Now,
Yes, Your Lordship.
I'll give interim bail and call
Yes,
the complaint.
In fact, if Your Lordship, I will just bring that to
Till
be very
returnable date, I'll
to be very precise with my submission, Your Lordship, since non-bailable warrant has been issued, Your Lordship, it can be only executed by the police, and the recalling can be done by the executing court, Your Lordship. Now, if that is the situation, Your Lordship can dispose of this matter with a direction that he appear on certain date before the before the court who has issued the NPW, and file a fresh bail application so that before the
till then he may be protected otherwise.
And that I could have done had it been an application under 482 for recalling the NBW.
No, your lordship can, my suggestions would be, your lordship, can protect him otherwise, and that give a certain that he may appear before the executing court on so and so day.
He will cooperate with the investigation.
Yes, and then till the time that he appears there and file for a recalling application before the concerned court, your lordship, he may be protected, but then thereafter he may file bail application whatsoever subsequently, your lordship. Because in that case, at least recalling will also be done. He will, in case of filing a bail application before the concerned court, if he is granted bail, your lordship, the IO will also, he might also cooperate with the IO. That would be much more convenient, your lordship. Because if interim is granted, your lordship, what will happen is he'll go before the IO, he'll give his statement, your lordship. Now, since the non-bailable warrant has not been executed per se with regard to the NBW issued by the magistrate, executing magistrate, your lordship, and then they'll come before this court saying that we have cooperated with the IO. We have also given our
So
statement.
that is, your suggestion is okay, right? That I will protect him till he appears
Before the concerned court.
court, CJM. And then his bail will be again, or that,
Because
let him remain on the bail, and then he will go and appear before the IO and pray for recalling of the same.
Yes,
Yes, Lordship. Yes,
he can do that, your lordship. But then my only concern is with regard to, since the non-bailable warrant, it's a warrant, your lordship, has already been issued, your lordship. It can be recalled by the executing court who has issued it, your lordship. During that period of time, your lordship, if this, if he's
Normally,
given,
what we do in this 482 application, we keep that NBW in abeyance. He
Yes.
should go before the court, and then the court will decide on bail.
yes,
But this is not this. This is an anticipatory bail.
yes, your
Yes,
lordship.
Lordship.
Right. So let him be on bail. He will appear on the next date, the date
Yes,
which he has
Lordship.
fixed.
Yes, Lordship.
Wait, I have not decided finally. This is, when is the next date fixed?
21st of July in
It's not
CGM.
written in the, it's not
It's
written in the,
in the TCR, your lordship, TCR,
where it is?
TCR, your lordship. There's another
Right.
file,
The order sheets.
the order sheet, your lordship.
Just show me. Okay, what did I say? And also write one thing. Miss T. Jeannie places a judgment of the Honorable Apex Court passed in C.T. Ravi Kumar C.T. Ravi Kumar.
Moni,
Not that.
there's a green file, your lordship.
Oh, yes, yes. C.T. Ravi Kumar. Oh, no. Cut that C.T. Ravi Kumar. I'm telling the judge, honorable judge's name. Shrikant Upadhyay versus State of Bihar and others. Reported in
Your lordship में 2024 AIR 2024 SC 1600, your lordship.
Oh, yeah. AIR 24 SC 1600. Wherein the Honorable Apex Court had observed that in cases where warrant of arrest or proclamation is issued, the court should normally the court should not normally grant pre-arrest bail except in extreme and exceptional cases in the interest of justice. I have heard the parties and have gone through the records. It is noticed that the petitioner has obtained the copy of the FIR on 27/5/2025. And also the copy of the order dated 7/1/2020 by which NBWA was issued against the petitioner by the Court of Chief Judicial Magistrate, Capital Complex at UPR. It is also a pleaded case of the petitioner that have you written somewhere that till 2020 you were working in the company?
No, my lord, actually, I am just stated that verbally. Already I have the mail paper because if I am physically.
It is also the learned counsel for the petitioner have also stated that he had been working as a sales executive in the
Consultant,
Itafort company
as a consultant.
till as a consultant, not sales executive.
Yes, look. I am
Now
as a
your-
consultant.
Your position, your post changed.
No, my lord, from the date of beginning, I am just doing my job as a consultant to
But it's
obtain the
written.
sales
Okay.
executive.
He was working as a consultant till December 2020. That is 1 year after. That is he worked for 1 year after the FIR was lodged. However, he stated that he did not know about the FIR which was filed 1 year back. Where have you pleaded that you did not know about this? Which paragraph?
Just one, my lord. My lord.
Paragraph 4, Your Lordship, at page number 3.
Hey, my lord. Yes, my lord.
The petitioner has pleaded the facts at paragraph 4 of his petition.
And my lord, I have 2 copies of the mail. If I am physically appeared, then definitely I am show it. But in my hand, recently I am collected. These are the email which I am collected from the company. Till I am working in the that dealer till December 2020. My lord. I have the yes, ma'am.
That December thing, na, after that you write for which he had placed few emails in the same connection. For which he has placed few emails in the said connection. Further, you are a permanent resident of Gitanagar?
Now, my permanent movable immobile property at Gitanagar, near about only 100 meters from the police station of Gitanagar.
Okay.
My house
Now-
number is 57 miles.
Further, it is noticed that the petitioner has a permanent residence at Gitanagar, Guwahati, and the police have also visited his place.
House number 57 miles.
It's okay. Now, what I wanted to show is that he will not escape. Police has also visited his place, and his family also resides therein.
Yes, with along with my oldest parents, my lord.
In view of the fact, this court, this court enlarges the petitioner on interim bail for by furnishing a bail bond of rupees 30,000. It's a lot. 30,000 with 2 sureties, one from the state of Arunachal Pradesh.
My lord,
Okay.
kindly be one surety, my lord. Because
No, one surety in Guwahati and one surety in Arunachal Pradesh.
because
You
my
will
lord
have- You
kindly
will
see,
have,
I live Arunachal from the year 2020. And my lord, if I am resident of permanently in Guwahati, so it's difficult for me to obtain the surety at Arunachal. I may be surety given in Guwahati available, my lord. Any point of time I submitted any bail bond from Guwahati, my lord, or any others in Assam, my lord. But unfortunately, Arunachal, some who are appeared on behalf of me, my lord.
Your
And
Lordship, since he was working here, he might know well aware of
That
any
is
local
what he
case.
said, but then he said after 2019 and 20, he is no longer.
yes,
here.
my lord.
With two sureties of the like.
In
amount
that
to the
case, Your Lordship,
satisfaction.
in that case, one of these surety may be a government servant, Your Lordship, because this is a
Okay.
huge amount.
And one of the surety will be a government servant, not in
My lord.
Arunachal Pradesh.
My lord,
we
two,
do-
two securities from Arunachal, it's maybe possible for me. My parents and my all the family or entire family relative are reside in Assam. But government service, if that it's difficult for me, my lord. I have
with
land.
with two sureties of the like amount to the satisfaction
my
of the
Must
CJM
oblige.
UPR. To the
Must oblige.
satisfaction of the CJM UPR.
Yes, my lord.
Your Lordship may also direct that
Ah.
meanwhile he will approach the court who has issued the NBW, Your Lordship.
Yes, yes. And the bail is subject to the following conditions. One, he should appear before the learned court of CJM UPR on the next date, which is fixed on 21/7/2025, positively, without fail. And if he does not appear, necessary steps may be taken by the authority concerned. Two,
If I may pray, Your Lordship, instead of it interim, let this matter be disposed of on the same order, Your Lordship. In that case, because he'll be appearing on that.
not
date.
interim, I'm disposing.
Yes,
He is granted pre-arrest bail. Yes, not interim. So he will appear before the CJM. Two, he will. Once he appears, this NBW will go.
yeah, absolutely,
CJM
Your Lordship.
will
Yes,
consider.
Uh,
He will cooperate with the investigation and will appear before the IO as and when called for, and will give his statement to the said IO. He will not leave the jurisdiction of the he will not leave his residential place
Your
because he will not here. He is there in Guwahati.
Yes, Your Lordship.
He will not leave Guwahati without the permission of CJM UPR.
Yes, Your Lordship.
He will not leave his place of residence without the permission of CJM UPR. He will not tamper and so with the evidence, whoever is connected that you say. Petition is disposed of. Okay.
My lord, must oblige. And my lord, I have one prayer, my lord. In each and every condition, I may be obeyed, my lord. I respect to the honorable court judges. My lord, in third condition, I definitely taken a permission from the honorable court because I am a builder, I am a businessman. And during my business purpose, I definitely some clients problem, some materials, then I'll go
No, for that you
anybody.
make an application before the CJM UPI and get the permission.
Yes, my lord.
But then it's difficult. Okay.
Okay.
Diploma.
Must oblige. Highly oblige. Highly oblige. Must oblige.
Mayor,
Yes, Mr. Sonar.
my lord, FIR, my lord, has already seen this case, my lord.
Which one?
This, my lord, we appeared in the exam. We were selected, my lord. Thereafter, we have,
AB.
not AB, my lord, my AB, my lord.
AB, yeah.
My lord. Day before yesterday, my lord, I argued and my lord just wanted to see this FIR, this CD today, my lord. Basically, the allegation is, my lord,
The scan copy is here.
Yes, Your Lordship.
my lord, the allegation in the FIR is only that, my lord, may I take to the FIR again?
Where is the FIR?
My lord will find FIR at page number 36, my lord. Starts from page number 36. contains, my lord, would find at page number 39.
I have gone through this FIR.
Yes, my lord. Here only, there is no any impediment measures, only saying that, my lord, there's suspicious.
Oh, yes, that's
Yes, ma'am.
suspicious.
Suspicious.
Oh, I remember.
Yes, my lord.
I was
In the month of September 2023, my lord. First part, first thing will come. Thereafter, my lord, final result was declared in the year 2020. Already concerned. If they were having suspicion over my acting, as mentioned in the till declaration of result, even results till declaration of why should they know? Immediately after examination, had they been very bona fide, good faith, if really they
there was
suspect.
an inquiry was going on in the
No,
meantime.
nothing is like that. My FIR, nothing disclosed. Let's further, man. Now again I will. Then 2023, I will say, okay, inquiry you do from 2023. I will say 24 also. No doubt. I will give 1 year extra. My lord. Then my lord will see how this FIR propped up. We were debarred. Penalty was imposed on us, saying that the reason given is that our corresponding address and permanent address doesn't match. We immediately put to challenge that order before the CAT. CAT has immediately stayed that order. Now, then, my lord, FIR was. Just to justify, just to support their order, my lord.
That is what you
There
said.
is very, my lord, clear mala fide, my lord. This is the only the intention, my lord. Now, my lord, another question. My lord, now my learned friend has referred to some other cases where GSM based devices were. Those cases were very concrete, where these devices were detected, were found, implementing materials there. I understand. If they have found something like that, okay. And again, then question comes, what are the criminal charges under one section that will be put against me? I should know at least. So my case is like that, my lord. This metal detector, jammers, everything was there. No instrument, nothing could be taken inside the examination. Now the question arises, if jammers and metal detectors, GSM based metal detectors could not detect GSM. Now, if at that point of time it could not be detected, after 3 years, how the prosecution will establish its case now? Then I use, my learned friend is just a kind of referring to some other incident. He said the possibility is there.
Yes.
Now, my lord, I don't understand. The metal detector could not detect. Now they are making allegation I used. I said that if metal detector could not detect in 2023, maybe I may be very over smart or I may have a very sophisticated.
She said it
instrument.
is so small that one cannot see.
Yes,
the
my lord, my lord.
Mm.
So question comes, how the prosecution will collect evidence that I use the metal, this GSM based device in the year 2023. Now,
That is why all suspicion.
also, now another question. It will contradict their own claim. Also, what is there in the FIR saying that suspected of visiting toilet repeatedly? Now the question comes.
And finishing your exam very
Yes,
early.
madam. Visiting toilet repeatedly. Now here is the glitch, madam. Now, if had I used GSM device, madam, no one will visit the toilet repeatedly. No one will waste that time. GSM is something like that, my lord. It is put inside the air. You have transmitter with you. You will not go outside. Then you will have that all the time you will see there. Why should you go? Then you will have the GSM camera somewhere. Immediately it will go there. Then you will not have a time to go to the bathroom. Why should you go when you are sitting? All the answer you are getting, my lord. I don't understand how this
Contrary.
contrary, my lord, a person will go to the toilet only if he doesn't know the answer. If he knows the toilet, if he knows the answer, why should one go? Even during our examination, when I know the answer of the thing, I will keep on finishing the first one. Then when I don't know, then I will think of, oh. Well, so this, even of course, there is nothing in the FIR. I am making this submission as my learned friend, try to stress this case, although nothing is there on the record, trying to compare this case with one of the case that was investigated where this use of GSM was recovered. So there is a material. The mic is 2023 and mine can see the chain of event. Had we not been debarred, had we have not put to challenge to their debarment order, this FIR also we came to know only through their affidavit. When they file affidavit in the CAT, there we came to know this is there. And I don't think so that they are also even serious of proceeding with this case. Only they want to show in the CAT, you see so many suspicious behavior because they found that this clerical mistake cannot be a foundation for declaring a candidate disqualified because Apex Court so many judgments are.
Address.
Yes, ma'am. These are the clerical mistakes. So when the CAT has discussed all those judgments, now they don't have any hope how to justify the order. Now another is that now they will make the submission. We found so many suspicious activities going to the toilet repeatedly, and this is contrary to their its own. But my lord, this authority has not claimed that we have used GSM. It is the public prosecutor who herself has said that that might be the possibility. But nowhere even the authority has said, even after examination was held in 2023, 2025 FIR was lost. Even after 2 years, they are not certain exactly what sort of criminal activity we did. It is completely silent. So this is a fit case, my lord. Not only for AV, my lord. This is a fit case for quashing. Even I have item number 18, my lord. I have put to challenge this FIR also. My lord, Bhajan Lal from there repeatedly, because law is very settled, my lord. When the FIR is not disclosing any cognizable offense, now question comes to me: can by subsequent investigation, can I give color to the FIR? My understanding, my lord, no, my lord. Otherwise, whole this quashing of 482 application will be of no use. Tomorrow, police can always say, during investigation, I have found this much. Then FIR will lose its own uses, my lord. Because FIR means what, my lord? It should disclose cognizable offense. There only the machinery should go ahead with the investigation. Now, investigation prosecution cannot say, of course, FIR has not disclosed the cognizable offense. We will proceed, come with the evidence, and we will supplant the FIR.
No. Bhajan Lal says that not only FIR, but the accompanying documents and the evidences that are collected
My lord,
So if accompanying documents that she has or the evidences collected by the police
my lord.
supports that there are some cognizable offenses, then of course no quashing. But as far as AB is concerned, this is AB. And you're
My lord, my lord, Bhajanlal, I have with me.
Hmm.
Number one, my lord, it's 102, my lord.
See, accompanying documents.
My lord, may I read? My lord?
Yes.
First, there are as many as, my lord, seven
Seven,
conditions.
yes.
First condition is that where the allegation made in the first information report or the complaint, even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out a case against the accused. This is the first condition. Now, my lord, my case falls under here. Let's take everything as it's a gospel truth. What is there in the FIR? But even my contention before my lord is that.
But in one of the guidelines, I think the accompanying documents and the surrounding circumstances
My lord,
are there.
that is there, but some sort of, even after taking my understanding, my lord, that is also there, my lord. Well, passing the my lord can look into other accompanying documents.
Quashing application.
Well, item number 18, my lord.
Ajay and 11 others.
My lord.
Achha.
Item number 18, my lord. But in 18, my lord, there is one issue, my lord. Today may not be, it may not be proper to take it up because I think, my lord, inadvertently, we have not included the informant in for it. So we would like to get the permission from this lord. We will serve the notice. Thereafter, that matter we will argue on that. Today, my lord, I may be protected, my lord. This is a case, my lord, because now, my lord, even GSM-based device that allegation will contradict their own statement, my lord.
Okay, let me hear
My-
Ms. Didi and her papers.
Your Lordship, we have received the CD, Your Lordship. If Your Lordship will first see the status report, Your Lordship, the comments, Your Lordship.
That the police will write.
No, I'll just come to the fact, Your Lordship. Lordship will see that I've just flag mark the side flag mark with a green flag mark, Your Lordship.
Blue. Oh,
Side
green one.
Side flag.
Oh, side one. Okay, yes.
It's
Yes.
a to whom it may concern certificate, Your Lordship.
Huh.
Your Lordship will see the signature was put by an executive magistrate, Your Lordship. During investigation, we have called upon the magistrate, Your Lordship, and tried interrogated her, Your Lordship. It was brought to our notice. If Your Lordship will see that this is of April 2023, Your Lordship. April 2023, Your Lordship. It was signed on April 2023 by the executing magistrate, Your Lordship.
No date. This is 1st July 23.
Your Lordship, first down below where the signature of the
22nd June, March. I don't know. This is handwritten.
yes.
This is Pooja. And
Yes.
is residing in so and so moral character. This is dated 1st July 20.
1st July, yes. Even otherwise, Your Lordship. Some of the documents are of July, some of them are of April. Now, Your Lordship will interestingly find that even these documents are forged, Your Lordship. Why? Because the executing magistrate who has signed this document, Your Lordship, he joined her office in the year on December 2023, Your Lordship. And Your Lordship will see, interestingly, the signature of the executing magistrate is of April and June on all the documents of the accused persons, Your Lordship. Now, the second is that I have just flag marked the WT messages, Your Lordship, with the pink flag mark, Your Lordship, in the first. Now, this WT message was sent to the Haryana police station, Your Lordship, with regard to all the accused. If Your Lordship will see that this address contain of the same address that are in the bail application as well as in the criminal petition, Your Lordship. Now we have been verbally informed that none of the accused were found in these addresses, Your Lordship. Now, another interesting fact with regard to address, Your Lordship will find, I have just flag mark, if I just take Your Lordship
But
to the...
whether this address issue is there in the FIR?
Yes, Your Lordship.
It's there.
It's there, Lordship.
Okay. I forgot.
Now, another interesting fact is that, Your Lordship, the documents, I'll just show that in case Your Lordship does not.
You can read it out. I can.
One of the accused almost all of the accused comes with the same place, Your Lordship. Since this is respondent number one is Ashish, Your Lordship. Lordship will find that these are the documents which are submitted before the SSC board, and then these documents are later on uploaded to the website of the concerned examination center, and an admit card is given, Your Lordship. Now, the first respondent in his date of birth is 2/2/1995. However, in the application received by the SSC board while granting an admit card is 12/2/2000, Your Lordship. Why I'm coming to that, I'll get to that later on, Your Lordship. In the same manner, the address that are given in the bail petition as well as addresses given in these documents, Your Lordship, are totally different to the addresses given in the application that was uploaded in the website, Your Lordship. Now, if Your Lordship will also later on see that all the applications have the same handwriting, Your Lordship. These are filled up by same person, Your Lordship. Even the verification, Your Lordship, we have only found one of the house owners, Your Lordship. We have found only one of the certificate which discloses one person's name. Rest of the persons, there is no person named as given in the certificates, Your Lordship. Only one person that we have found, one lady, she also denies that I have ever issued such kind of certificate that they are a permanent resident of this place, Your Lordship. Now, culminating to this entire documents, Your Lordship will see, this is not a simple case of just uploading a document given. In a state of Arunachal Pradesh, when the ILP was banned to be given to anyone from 2020 to 2023, Your Lordship, it's when the examination was held, Your Lordship.
ILP was banned.
Yes, this was subsequently, we have also sought for these documents where the order for banning of the ILP from 2020 to 2023 was made, Your Lordship. Now, this could not, because the concern certificate, Your Lordship, and the declaration, Your Lordship, naming certain person being the house owner, Your Lordship, whereas such persons are not even available, Your Lordship. This could not have been done by any person of staying in the state, Your Lordship. And they could not have been allowed without an ILP to get into the state, Your Lordship, for examination. Now, the third is, Your Lordship, the address given of Haryana is also does not match from the document that they have submitted before the SSB and the documents that they have uploaded, nor the date of births were clearly mentioned, Your Lordship. Now, these documents was obviously during the documentation, this document had or might have been verified, Your Lordship. Subsequently, therefore, investigation is also with regard to the concerned SSB staffs who had uploaded the documents, Your Lordship. Why? Because if there was no nexus between the SSB staffs who are responsible for uploading the documents, because these documents given in before the SSB and then these documents being downloaded are totally two different documents, Your Lordship. Even investigation in
mean to say that
many people also involved. Now, since during 2023, the examination was held, Your Lordship, and this is 2025, Your Lordship. Some of these staffs are no more working with the SSB, Your Lordship. We are also getting into those, the investigation is also directed towards getting hold of who were the staffs during that period of time and who had uploaded the documents, Your Lordship. Your Lordship will also see the interesting fact that the forgery that they have made of the executing magistrate, who was not even posted at the time of Your Lordship, her signature was being forged, Your Lordship. That could not have been done by some people who are very much well aware of the entire offices, Your Lordship. Now, at this stage, Your Lordship will see, as I have pointed out, Your Lordship, the addresses given in, if Your Lordship is even, if Your Lordship even grant bail, Your Lordship, it will be difficult for us because the Haryana police has also, as the given address we have given to the Haryana police, Your Lordship, it's very clear in the CD, Your Lordship. Even the Haryana police has stated that there are no person of such nature living in this address, Your Lordship. Then how can we believe that the address that they have given, which is the address given in this documents, are the real addresses, Your Lordship?
So your submission is only with respect to the wrong addresses given?
No,
uploaded before-
and the forgery made, your lordship.
And the
Forgery
forgery made
made.
of the executive,
In-
of the magistrate.
Executive magistrate, your lordship.
Executive magistrate. You are not on those devices now.
No, no, there is also one, the status report also, if I may just read, your lordship.
Now, new case I have.
No, I'll
It's
just
not
read.
there in the FIR.
My senior friend should not be very much.
Go through once.
Yes, your
Yes,
lordship. If I may just read the entire comment, your lordship. The first comment is that during investigation, the complainant has provided document of certain certificate and self-declaration of alleged accused person, which was submitted by alleged accused person as at SSC Center. Accordingly, it was thoroughly examined and verified. Upon investigation, it is learned that the said documents were forged by forging the signature of Miss So-and-so, Circle Officer cum Executing Magistrate, Naharlagan. Moreover, it is pertinent to mention that the said Executive Magistrate had joined the office at Naharlagan on December 2023 and wherein her signature is signed on April 2023 as per the document submitted by the alleged accused person. Thus, there is high reason to believe that the alleged accused persons are involved in committing the crime from the very start. Forgery is also there, your lordship. That the name and address of the local guardian mentioned in the concerned certificate and the declarations were verified, but no any such characters were found. Moreover, the records in administrative was also checked and verified, but no any records in this regard could be availed, your lordship. That a similar case has been registered at ITA PS, wherein the modus operandi of all the arrested accused are believed to be same in nature in comparison to this instant case. Moreover, all the alleged accused person in the connection with Itanagar PS case are Haryana based, and alleged accused person in this instant case too are from the Haryana base. As such, there is a high chance that they might all be correlated or of the same nexus. That the recording of statement of the executive magistrate is called upon this failure. That is, it's learned that the issuance of inner line permit was off from the year 2020 to 2023 December, wherein the documents provided by the alleged accused is contradicting the date and signed in the document. Thus, there is a reason to believe that the documents were forged by the alleged accused. These are the grounds at this stage, your lordship. Since the investigation also is at a very nascent stage, your lordship, because your lordship will see the FIR does not disclose anything. We had not been provided with any documents except for the documents of the documents submitted before the SSB board and the documents uploaded in the website, your lordship. Only with those documents, we are trying to get connected in this investigation, your lordship.
No, yeah.
And once, just go through the FIR, because last
Yes.
time I went through, but then I forgot it.
Yes, madam. Malab, in
What
the
is
FIR,
actually the allegation?
FIR, malab, basically, malab, in the FIR, my lord, there is no such allegation of I have forged any document of executive magistrate. Any particular document, there is not a single mention that I have forged this document, this document, this document.
No, those may not be there, but then I have submitted those documents, whether those are there. Just
Submitted
show me, I'll just read it
FIR,
once, FIR.
my lord, kindly turn to page number 39. 39.
Yeah.
May I start, read from the start, my lord?
Just to inform.
Sir, yes. It is to inform that multitasking Nartagli so-and-so, Havaldar so-and-so was
Conducted, okay.
conducted on so-and-so, September 2023. 3/5 in the designed examination center and so-and-so and so-and-so in the district of Arunachal. Certain irregularities and malpractice were observed. And it is suspected that 13 candidates who had appeared for the exam were involved in the same. As on today, well, certain irregularities and malpractice. Now, first, examination details. The step selection commission by notification that invited application for recruitment of so-and-so and result thereof was declared on so-and-so. During scrutiny, the commission observed that a total number of 13 candidates who appeared in the so-and-so from the Naharlagan have secured very high ranks, and 8 candidates are within the top 60 merit position. The total numbers of the candidates who appeared from the same venue were so-and-so. Accordingly, the CCTV footage and candidates CBSE answer logs details of 13 candidates pertaining to has been examined, which prima facie raises some suspicion regarding irregularities and malpractice of the 13 candidates while undergoing the examination. Suspicious activity observed. During the examination, it was observed that the 13 candidates appeared at the examination center were frequently visiting the toilet area and exhibited suspicious behavior. This candidate visited bathroom multiple times during the exam period and taking usually long time, and it appears that they have answered question without using rough sheets. It has been further reported that analysis of candidates' CBE answer log details revealed that these 13 candidates have answered 30 to 50 questions within 2-3 minutes, which is highly implausible and normal examination conditions. This rapid answering pattern is inconsistent with the time and cognitive effort required for answering examination questions, especially when no other candidates displayed similar speed in answering, which arises concern about the possibility of unfair practices and conspiracy on their part. Now,
What is this CBE answer? The analysis of
CBE answer
candidates?
log details, my lord, maybe log.
Candidates
computer-
CBE answer
Yes, my lord,
log
I think
details.
in the computer, it was a computer-based examination, online. So while I think clicking this computer,
Okay, that is what.
so at that time some log may develop there.
30, 50 questions.
No,
not-
they are saying, well,
This is what. we
this
are
is
doing.
now my document verification part.
Hmm.
Upon suspicious activities being observed, the 13 candidates, it was found that out of 13 candidates, correspondence and permanent address of 11 candidates are in A sector, G sector, Nahalagan district, Papumpare, and all candidate is same. Further, all these candidates had mentioned their address of Haryana in the commission copies filled by them during the examination. After that, when the candidates were called for physical document verification, out of 11 candidates, only 10 candidates attended the document verification and 1 candidate was absent without any justification. And out of 11 candidates, 10 candidates have mentioned Arunachal Pradesh as their permanent address in their original application form. And at the time of document verification, they have failed to provide any documents in support of their permanent address mentioned by them at the time. My lord, here I pause for a while. Now I am alleged that I have created a false document of Arunachal Pradesh. But the allegation is saying I failed to provide any document showing Arunachal as a permanent address at the time of document verification. This is the allegation. That part I will come later. Failed to provide any documents in support of their permanent address mentioned by them at the time of filing of the MTS application form, which raises serious concern about the possibility of unfair practice and conspiracy. Moreover, at the time of filing of the document verification form, some of the candidate has filed a new address which is neither matching with the correspondence and permanent address filled at the time of the MTS examination, which prima facie shows the discrepancy and malpractice on the part of the candidate, which is a clear violation of and so and so. Now, further, as per the notice of examination, that dates of window for correction so and so was provided to all the candidates on and between so and so, meaning thereby sufficient opportunity was given to all the candidates to correct the application form. In spite of this, the above candidates mentioned have not corrected their addresses, which shows that all the above mentioned candidates have hand in glove while engaging in suspicious behavior and practice while undergoing the exam by choosing the same center of examination Arunachal Pradesh and committing the same mistake which no ordinary prudent man or woman could have done so. These facts and patterns strongly suggest the possibility of a well-organized conspiracy involving the candidates. Considering the above facts and situation, and also while undergoing CCTV footage from the examination center, candidates' application forms, candidates' response pattern, showing an unnaturally high speed of answering question, and the document verification of the candidate discrepancy candidates malpractice by engaging hand in glove along with external collaborators in the center. This hereby requested that thorough investigation be conducted in the activities of these 30 candidates to determine the nature of their involvement in the conspiracy. There is high probability that there is involvement of external collaborators also who had undermined the integrity of the examination process. More people from various states may be involved. Therefore, thereby it is requested to take appropriate legal action against all the persons involved as well. So, below are the section which is. Now, my lord, I pause. Now, my lord has seen this. There is no any whisper of we creating any false document or rather, their reason for debarring us is that we failed to produce any supporting document of Arunachal Pradesh. That is the reason why we have been debarred. So, we have, and moreover, this issue for this Malad, there is a guidelines. If such mistake is done, window times were given, not done, they have taken the action against us. We have not been only disqualified, rather barred for 3 years for the mistake matter. Now, our claim was that it was not deliberately done, but because my lord, we are a class 10 pass person. We are not something very highly educated or having a we are group C post, my lord. We are not something coveting for a very high post or something very graduate person. We take the help from others to upload even money. So in the process, some glitch. So it is ourselves, we said that there is a change in the permanent address of the correspondent. It is ourselves, we went, we sought for the correction. That was not allowed and we were barred. Barred on the condition, today PP has changed the allegation.
No, I'm still on that.
Today there is no, this my lord has seen that GSM, this device is, at least today is not against me. Now his questions, what document are we have forged? My lord has seen that. Rather than saying that we failed to provide documents. Had we provided the documents from our nature, then might be our even disqualification would not have been there, man.
But you did not go for correction of the address. You were called, but then you did not go.
No, when the window time, within window time, we did not go. Thereafter, before physical verification, we wrote application saying these are the mistake happened. We would like to allow us to correct.
Where is the documents to show this that they went and wanted to give the proper address?
Representation, man. Not representation, man. Yeah, yes, na. We can't file here. My lord, may I take to page number? Let's start from here only. Copies of the AV. My lord, kindly turn to page number 154.
Maybe Chairman, replacement in permanent address.
Yes. So we sought for the, my lord.
It is the petitioners. Better.
Yes, petitioner, my lord. This is one of the petitioner, Ankit Yadav, my lord. Thereafter, my lord, will find another representation also, 160, my lord. Page number 160. Then, my lord, will find this is also Ankit Yadav. 165 maybe. Then there. Puja also. Now, my lord, now the issue is, my lord has seen, my lord, so far the commission has not alleged that we have used any.
But this is 15/5/24.
After the exam.
My lord?
After the.
Yes, after exams, after declaration of the result, my lord. Because, my lord, it is something. Process is like that. After examination, result was declared. After result, my lord, then physical test was done, that was also qualified. Then there is a date before final appointment is the paper document verification. So on that document verification, I have to appear along with the original. So before that document verification, my lord, when we found that there was some discrepancy, my lord, we requested allow us to correct. Now, my lord, this issue so far giving. Now one question I put myself. Let's assume I knowingly gave the wrong address. Is it a crime? Which penal code says that giving wrong address is a crime? Even if I don't stretch my, but my case is not deliberately. I am just for the sake of argument making. Even if I say that address was wrongly given, my lord, but I don't see any penal laws for that one, my lord. For that one, here is a provision is called, my lord, under the guidelines that at the most I can be disqualified. I have been disqualified. But there has said, considering the apex court judgment, serious judgment said that this is a clinical mistake. You, as of today, my lord, final decision has not been taken. Prima facie, the case is of the view that this matter needs to be stayed. And my lord, if my lord wants me to show that the judgment order, I can take my lord to the gate order also.
Not required,
Not
there
required,
is
not
only a BA.
So now the question comes, my lord, now case has shifted to other part. Then use the document. Now I don't know from the FIR, my lord, which document I have used, which is a false document. Has to be there, my lord, particularly which particular document is the false document. Number. Next one. The commission is saying that rather I did not provide any document supporting my address in Arunachal. Now the PP has made a contrary statement that I have made a false document in the state of Arunachal. So this is again a contradictory statement. Apart from this case, my lord, now this is a matter of 2023, all this thing happened. FIR was filed in 2020. I have shown my lord that plausibility of my defense that this is malafide because this has been filed only when stay order was granted. This sufficiently shows that there is a motive why this FIR should be filed. And my lord has seen also, if they were doing inquiry for more than 2 years, they should have come with some specific allegation even in the FIR, my lord. That is also absent. Now, my lord, other law. Now, if I come to the law, it is the offense, my lord, at the most 7 years or 6 years. Now, even if you say that forgery also, case of 225 January registered, my lord. Now till 6 months. Now, my lord, amendment of the BNSS, my lord, and until judgment, my lord, says that such cases notice is mandatory. 6 months has lapsed. Police has not even sent notice to me. And until this judgment says that not following that itself entitled me to get the privilege of the bail, my lord. My lord, may I take to this judgment, my lord? Just read out the relevant paragraph of the Para 20 says that the consequence of non-compliance with the section.
Give me the citation.
My lord, citation is 2022.
There are so many until 2020.
22 10 SCC, page number 51, my lord. Satyendra Kumar until, my lord.
Paragraph.
And see, para, my lord, I will para 23, 25, 26, my lord.
You're reading for SCC.
My lord, SCC, my lord. I will read from, my lord, para 25, my lord. Para 25 is saying, my lord, as last time also I submitted, for the offense up to 7 years, only satisfaction of prima facie committing offense is not satisfied for that. Another requirement is there is reason to believe why this arrest is necessary. That reasoning is very more than above prima facie is sufficient. Right. So here is the case, my lord. This is section 25, para 25. The consequence of non-compliance with section 41 shall certainly inure to the benefit of the person suspected of the offense. Resultantly, while considering the application for enlargement of bail, courts will have to satisfy themselves on the due compliance of this provision. Any non-compliance would entitle the accused to grant of bail. So, what prevented the police, my lord, from this last 6 months? They should have sent me notice.
In all the offenses, the punishment is less than 7
All
years.
are bailable, my lord. Only 468 is 7 years, my lord. All are bailable even, my lord. Now, my lord, now this judgment has all dealt, my lord. My lord, this issue of clogging jail, all this aspect has been taken. And the court is of the view, my understanding of the reading of the judgment and series of judgment is that court is saying for the offense up to 7 years, generally, bail should be as a matter. Generally, for every offense, it's not necessary one should send them jail generally, madam. Unless certain circumstances, exceptional case where citing there is. And my case, my lord, this alleged to have happened in the 2023. More than 2 years, 10 years, FIR was filed on. Had the commission been serious, madam, they would have pursued the matter. This is a completely case to justify their order. When they know that they don't have any way now to argue before the gate. This is a very complete, my lord, open picture, clear picture. This is the.
Okay, I'll pass the order
Well,
in the chamber.
Deeply okay.
Yes, Your Lordship, I'll just come to that, one of the submission made, Your Lordship. With regard to the, let me take Your Lordship to the notice.
If I consider in giving bail, I'll put certain
Nice,
conditions
my lord. I'll
that
take care.
local sureties and
My
all.
lord, local,
Your Lordship-
that maybe we may have difficulty, my lord. My lord, and
No,
nowadays-
actually, Your Lordship, because one of the.
If I decide.
Yes,
not
if
decide.
that I was trying to suggest, Your Lordship, if Your Lordship decide, Lordship, I have already placed my CDs saying that we have contacted the Haryana police, Your Lordship. They have informed us that there is
They
no
did not
person
state.
because the same address is in the petition, Your Lordship. Now, if one of the accused says that he has a relative in the state of Arunachal, Your Lordship will also consider that why such affidavit was or the certificate was necessary that a person should be from Arunachal. Why was they in they needed such certificate from an executive magistrate to declare that they were permanently a resident of the state of Arunachal?
Requirement.
Exactly, and therefore the forgery came into existence. Your Lordship will also say, I'm just suggesting, Your Lordship, if Your Lordship grants bail, Your Lordship, at least some documents like the Aadhaar card where the address are, or driving license, because we are not able to find the address. The contention being made that 41A, Your Lordship, with regard to 41A of the CRPC, the corresponding is that 41A, even the Haryana police are not able to find the addresses, Your Lordship. There is no question of us also not finding the question because we are taking the help of the Haryana police.
They send this 41A. This
Yes.
is what.
Now, my only suggestion is that if Your Lordship is, if allowing for any interim, Your Lordship, because we are also after them, if interim is at least given, if they come also, we are being helped, Your Lordship, because we are having a trouble with regard to investigation also, only because of the fact that all of them are from Haryana. None of their addresses are reachable, Your Lordship. Even the phone numbers given in the petitions are all switched off, Your Lordship. None of the phone numbers given in the petitions are available. If Your Lordship consider the interim, Your Lordship, because the executing magistrates, this is also pending, Your Lordship. She has been called for her giving her statement, Your Lordship. At least 2% surety, Your Lordship, one of which has to be a local person or if not so, a government employee, Your Lordship. It is mandatory, Your Lordship, because these people, even the Haryana police are not able to trace them out. It will be difficult for us to get them, Your Lordship. Second is that, Your Lordship, their appearance before the IO every month, every first week of the month, Your Lordship. That has to be made, Your Lordship. The third, Your Lordship, will consider that including all including all the conditions, Your Lordship. One of the conditions shall be that they cannot move around without the go out of the jurisdiction of their place without the permission of the IO, Your Lordship. Because if these conditions are not strongly put up, Your Lordship, neither the addresses given in the SSB board, neither the addresses given in the uploaded website, Your Lordship, nor the addresses given in the petition, nor the phone calls are all not traceable, Your Lordship. If that is the condition, Your Lordship, it would be difficult for the investigation to investigate the matter.
Results are out, right?
Results are out, Your Lordship. They have passed in 2024. They were debarred before the FIR was filed, Your Lordship. That's when the SSB board, while evaluating,
Take appointments or what?
debarred from appearing on all the examination, which
So
they
means disqualified from this result itself.
result.
And saying that for 3 years I cannot participate in any
In
examination
examination.
by the SSC.
That SSB part is totally different, Your Lordship, because there are clauses in the notice where it's clearly stated that if they fail to give those addresses or improper information, they'll be debarred from the appearing in exam. That clauses are there in the notice, and therefore that was done. That is separately being challenged before the CAT, Your Lordship. That's a totally different issues, Your Lordship. And even the clauses in the notice, I'll just read, Your Lordship. Notice concern the advertisement. There is a clause which says, if I may read, clause 20, attempt to hack or manipulate examination servers, data and
Is that
examination.
page number?
Your Lordship, page number 70 of the, it should be 67, 70 in the writ, criminal petition, Your Lordship.
Tell me.
You just read out then.
After notification, na?
Clause 20.
And when they will go to the police officer to give their statement, they'll have to place the Aadhaar
and this card.
to show their correct address.
Yes, yes. I'll just read otherwise. Attempt to hack or manipulate examination servers, data and examination systems at any point before, during or after the examination is 7 years of punishment, Your Lordship. Your Lordship will see 22 says the Commission may also report the matter to police investigation agencies as deemed fit. Commission may also take appropriate action to get the matter examined by the authority or forensic test. So these are provision provided in the clauses in the notice for examination also, Your Lordship. And therefore, when in 2024, when they were debarred, their documents were evaluated and certain anomalies were found. Subsequent to that, Your Lordship, further evaluation of the documents as well as on the last time I have made my submission, Your Lordship, because of that database equipments, Your Lordship. On that suspicion only this FIR was filed. If this FIR was filed before 2024, before the debarment, it would have been a different case. That CAT matter is totally with regard to a 2024 evaluation of the document, Your Lordship. I will leave it to Your Lordship's discretion, Your Lordship.
I will pass the order. I have not decided yet,
My
but
Well, this was is saying that our address not found. Very surprising. My lord, this whole physical document, my lord, we want to have a job. We are really in search of job. My lord knows the unemployment problem in our country. People are so desperate. People have a responsibility, have to leave that life. We are the job. Why should, after having done exams so nice, why should one knowingly go for all this problem?
Absolutely.
We have to put that on also everything. Here is the, my lord, this of course, we are not saying that there is no change, there is some error between the correspondence and permanent. Now, my lord, let me say about the address. Now we went there, we produced our physical original document during verification. And only when we saw unless my lord, I don't show my original document. How the commission will verify the document? It is only after when I saw my everything, original document, then the commission says that there is a change in this correspondence as well permanent. Now that issue for that one, my lord, we are not saying that there is no error. We accept it. And they have divided us. But the CAT is saying that this is too disproportionate. They're just for making this error. Now you say that first I will disqualify you from examination, then I will not allow you for 3 years more. This will not be a sense of justice. Much of life.
Yes, Your Lordship. I'll just make a reminder, Your Lordship. Your Lordship, my submission with regard to, because they were so desperate for exam, they had to get a certified copy of a forged document by the executive magistrate to declare them that they are permanent resident of the Arunachal. That may also be taken into consideration because we are yet to take the statement of the executive magistrate, Your Lordship. We have shown her she had
joined later, but then her
and she has been her signature has been forged. That has to.
We may kindly be protected, my lord, and my lord, leave my lord with
no question of interim. I will dispose of the.
Yes, Your Lordship.
Yes.
Yes.
My lord, yes. This can. Then my lord, 18 number, my lord, I may be allowed to implement the comment. Item number 18.
Okay.
Similar.
Okay. Item 18, you write, heard Mr. Rajesh R. Sonar and Jimmy. Mr. R. Sonar states that inadvertently the informant was not included in the instant application. Here the informant is the staff selection.
Yes, yes.
Looking into the merit of the case, it is necessary that this court hears the informant as such. Do you have a pleading application? We did not.
No,
My lord, if allowed, then we can do it, the change in the cost that we used to do in these years.
Normally what happens, we file an pleading application, I'll allow this,
Yes.
then you change the cost statute.
It's up to you, my lord.
You
My
know,
lord, if allowed,
You
then
file
we can
an pleading.
one
then the
application.
matter list it may be listed when day after tomorrow.
Or day after tomorrow.
No, then we'll.
Then Mr. Sonar is allowed to file an pleading application, matter to be listed on day after tomorrow. On Thursday. Yes, then we do. Along with the is the
It's there. No, the green file is there. Green.
The case ID is in green file, Your Lordship.
That's it. Okay, it's there. Number one. Oh, one. Why did you take time? I forgot.
My lord, was
Oh, yes. that-
discussing on the right forum
Mm.
for the appeal, my lord.
Appeal
Yes, my lord.
from.
My lord, may I kindly have this book, my lord.
Yeah.
The Arunachal Pradesh Civil Code Volume 1.
Volume?
One, yes. Here, my lord, some amendments were made, my lord. My book. I don't make kindly. Turn to page number 53, my lord. This is Assam Frontier Administration of Justice Regulation 1945, my lord.
53, I think in this book is different. This is chapter 2. Okay. You're referring to volume number 1, right?
Yes, my lord.
What do you want to show? Which?
So, my lord, I want to show the in second provision of section 3 of section 15, for the existing entries, the following shall be substituted. Now, provided further that in case the Deputy Commissioner could not dispose of the pending appeals in their courts within 1 year from the date of commencement of the Arunachal Pradesh Civil Code Act 2021, they shall transfer such pending appeals cases to the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Court of Additional District Judge, or the Court of District Judge, as the case may be, as per their territorial and pecuniary jurisdiction. Provided also that in case an appeal is transferred by the Deputy Commissioner or prepared against the judgment of the customary court in the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, the Court of Additional District Judge, or the Court of District Judge, as the case may be, shall appeal, such appeal shall not be set aside merely on technical ground or procedural lapses, but in the interest of justice shall be disposed of as may be deemed appropriate or proceed with the case de novo. Provided further also that further Deputy Commissioner has already transferred appeals of pending civil suits to the Court of Additional District Judge or the Court of District Judge in terms of the second provision of subsection 3 of section 15 of the Arunachal Pradesh Civil Code Act 2021, the Court of Additional District Judge or the Court of District Judge, as the case may be, may further transfer the appeal to the Court of Civil Judge Junior Division, the Court of Civil Judge Senior Division, as per their territorial and
Now, what we can
yes.
deduce from here is before Assam Arunachal Pradesh Civil Court came into force, the appeal was before the Deputy Commissioner.
Yes.
When it came into force,
yes.
the Deputy Commissioner were directed to dispose it of within 1 year. If he cannot, he'll have to transfer the case.
Yes,
to
my
civil
lord. Yes, my lord. And after the appeal cases were transferred to the district and this additional district courts, my lord. If they have not disposed of the matter yet, then in that case, my lord, it has to be further transferred to Civil Judge Senior Division or Junior Division as per the pecuniary or this territorial jurisdiction of the court. Now, my case is that, my lord, initially, the petitioner along with two other parties, they have executed and work, my lord, but they have not completed the execution of the work. In the middle of the work, my lord, the judgment, the judgment holder, he had
Judgment.
yes, judgment, yes,
Debtor.
holder, yes. I'm the judgment debtor, my lord, the petitioner, my lord.
Wait, a petitioner with two others had taken up a contract work.
Yes,
What
ma'am.
happened?
Yes,
They
my
could
lord.
not complete. Then one of them took loan.
Yeah, one of them took loan.
Then
My lord, since
other,
yeah.
he filed a complaint before Keba.
Yes, my lord. That is, my lord, may kindly come to page number 60, my lord. And the translated copy is page number 17. We can, my lord, come to page number 17, my lord. This is the cover of 2/5/2023, my lord. My lord, may kindly see. Today on 2/5/2023, cover is conducted regarding dispute of the contract work undertaken by Sri Sembi Romin Longa Gamkak and Sogjum Gamli. And cover is at Lipu village. During the cover, it's bring to notice that to carry out the contract work.
So Sembi Romben had borrowed rupees 5 lakhs.
Yes, my lord. After calculating, this borrowed money had been solely repaid by Sri Sembi Romin along with the accrued interest. After calculating the principal amount and interest amount, it was decided that each one shall pay Sri Sembi Romin. And the amount of rupees so and so only has been paid with the interest. And it was decided that the remaining contract work shall be completed by 3 of them. The cover decided after final bill whether there is a profit or loss, but both Sri Sogjum Gamle and Sri Longa Gangkak shall get all the payment by excluding the share of Sri Sembi Romin so and so. So,
okay, it was decided that all of them?
Yes.
No, both of them?
both of them, my lord, because at the time of this conduct of this cover.
7,80,000.
Yes, my lord.
It was 5 lakh was borrowed but because of the interest, it had become 7,80,000.
Yes, my lord.
And was reserved, contract well shall be executed by 3 of them.
Yes, ma'am.
That after the final bill, when there is a profit and loss, so to gambling, Longa shall get all the payment by excluding the share of Sembiromi. Okay. So
Now-
7,80,000 will be given to the person who had borrowed
Yes, my lord.
Hmm.
Here the
amongst the profits.
Yeah,
Rest will
respond-
be
Yeah.
divided.
Yes, my lord.
Then
Next cover decision, my lord, another cover decision was there, my lord. Here, my lord, the cover has, my lord, only directed me alone to pay this entire amount of this 7,80,000,
right.
yeah, to the judgment.
so nothing was stated to be, nothing, Longa Gambok need not pay
Yes,
anything.
yes,
You
he,
have to.
I have to, my lord.
Why?
That is why, my lord, I have filed the appeal before the civil judge senior division at Alo, my lord.
Then-
All these irregularities were there in this attending this cover
Then this,
decision.
decree was executed by the deputy commissioner.
Yes, thereafter a decree execution this proceeding was initiated
Hmm.
on the initiation of the
Hmm.
decree holder, and on 14/5/2025, without following the provision of section 51 of CPC, my lord,
Hmm.
he has straightway, my lord, issued warrant, my lord.
He has to follow 21 of the CPC.
My lord.
He has to follow section 21, order 21 of the CPC.
Yes,
Well,
section 51 and the order 21 of the.
21?
Yes. He has not followed that, my lord.
Then
Because my lord is ever what is provided in this order 21, my
what
lord.
is that procedure?
Yes. That was not done, my lord. Straightway what he did, he issued this order, my lord, execution petition. When this order was
Hmm.
now, my lord, my lord, may kindly come to page number 24, my lord. 24 is not clear, my lord. Before passing of this
To the deputy commissioner.
additional deputy commissioner, my lord.
Acha, you have filed
Yes, I filed, my lord.
that the proceeding is pending.
Yes, my lord.
Appeal against the Kebang decision.
Yes, my lord.
Then he did not stop.
He did not stop, rather he went on to issue this order of 14/5.
तो फिर वो जो आया है क्या, वो तो जो आया है, हाँ तब तो हम अभी बीसी में ज्वाइन किया था।
Hey, you have given it on 11/6 or when?
आज
The date is not
क्लैरिफिकेशन
there.
ट्रिप था ना।
When did you give the intimation?
Intimation is on, my lord.
Date is not there.
Yeah. My lord, I have given it on 10 itself, my.
Eleven 6/25, that is after the order.
Yes, my lord. After this, my lord, representation, my lord.
Where is the date? Oh, it is at the top. It is not visible. It's not
10 years, my lord. 10/6.
10/6.
Yes, my lord. instead of this, my lord, holding the proceeding, my lord, he has now issued, my lord, this order, my lord, last page, my lord, annexure 5, my lord,
Which page?
annexure 5, last page, my lord, page number 26.
10 June,
Yes, my lord,
same day.
same day, my lord.
Judgment letter, therefore, okay. So now you want stay?
Yes, my lord.
Yes.
Your Lordship, may kindly come to page 23, Your Lordship. The condonation of delay filed by the petitioner in preferring appeal, Your Lordship. Page 23. It's dated 9/6/2025, Your Lordship.
Yes. Condemnation of 226 days.
Yes.
In filing the civil appeal.
It has been, it is barred by limitation, actually, Your Lordship. Appeal has page 21. It's dated 14/5/2025. May I read this order, Your Lordship? Today, this case was fixed for payment of decretal amount of rupees 7,80,000. The degree holder present, the learned counsel for degree holder, Mr. R. Romin Advocate, also present and submitted that an objection petition filed by judgment debtor is defective and has been filed without following legal principles and provision under Code of Civil Procedure 1908. After careful observation, it is found that the objection petition has been filed without following relevant provisions of CPC, and moreover, the statements made in the contents of the objection petition are all about facts of the case which can't be considered at the stage of execution of degree. If aggrieved by the Kaba decision, the judgment debtor was to file an appeal against the Kaba decision, but was not done on the part of judgment debtor, and the same was barred by law of limitation. Taking all these into consideration, the objection petition filed by the judgment debtor on 14/11 to civil prison for the recovery of the decretal amount. The next date is fixed for 10/6/2025, Your Lordship. After this order also, Your Lordship, the payment has to be made on 5/6. He has not paid, Your Lordship, and the next date was fixed on 5/6/25. Instead of Your Lordship paying, he has filed this condonation appeal, Your Lordship, condonation of delay petition, Your Lordship, before the civil court, Your Lordship. And Your Lordship, and he has submitted this representation on 10/6, which we have received on 11/6, not on 10, Your Lordship. If you see in page 24, Your Lordship.
11/6.
Yes, 11/6. And on 10 June, Your Lordship, the executing authority has passed this
The delay is not condoned.
Yes, Your Lordship.
So, and then you did not file it within time. You had waited. There is a delay of 226 days.
That is
You
true,
should
but
have filed it immediately after.
that has
So,
not been
this,
done by the petitioner, my lord.
execution had started. Thereafter, you had filed. And you were supposed to pay the amount by 5/6. Then on 10/6, on what is 10/6, you have given the intimation.
Yes.
And you have filed your civil appeal as with the limitation application or with the condonation application on 9/6 after you were directed to pay.
Yes, Your Lordship.
Your conduct is not good. So interim, I will issue notice.
Yes.
On the next date when the other party comes.
My lord-
Then only.
My lord, that is not only the ground, my lord, I have taken in this
What
revision petition.
correspondence
Otherwise,
assistant commission. or respondent number 2 is there, who is supposed to get the money, right?
Yes, yes.
He is the creditor. What
Yes,
is what
yes.
you say? Creditor.
My lord, if the stay is not granted, my lord, the filing of the civil appeal, my lord. Expeditiously. In such cases,
Yes,
That
It-
trial court will decide. They have issued notice on the condonation
my
application.
lord, I am relying on one judgment, my lord. This from
Because had you filed the appeal immediately
Yes,
after
your
the-
lordship.
then the matter would have been different. Latches and delay has come into
My-
play.
yeah,
You are not
that-
very
that is,
cautious in dealing with your remedy.
in fact, yes,
Which
since, my lord, para 6, para 8, may I read from para 6, my lord? Section 51 of CPC defines the jurisdiction and power of the court in execution of a decree. The main the court may, on the application of the decree holder, of the decree inter alia by attachment and sale, or by sale without attachment of any property, by arrest and detention.
Detention for such period.
Such period, not this one, sir. In section,
Without attachment. See, order execution of the decree inter alia by attachment and sale, or by sale without attachment of property by arrest and detention. Then enough power has been granted under this section.
my lord, the first thing, my lord, the executive court ought to have initiated was that, my lord. 115, page number what, my lord?
And see the further part. When you do not pay the money, it is also reflected in the same judgment that you have just referred. If you do not pay the money, and then detention can be ordered. After, of course, giving you an opportunity of showing cause. And here, in the order, that opportunity was given to you.
Yes, my lord, but
Yeah. That opportunity is given to you before, because fixed for so-and-so last payment, failing which the judgment determined. And you have also filed an objection which was defective.
Yes.
my lord,
There is objection petition filed by so-and-so without following the legal provision of CPC. It is found that the objection petition has been filed without following, and moreover, the statements made are all about facts of the case.
my lord, normal course is this, this before taking up such harsh steps, my lord. The executive court could have, my lord, attach the property, my lord. He should have inquired if I have any property or not. After that, my lord, after attachment, if I violate the attachment, then only, my lord, warrant should follow, my lord.
But
In normal case, my lord.
Without attachment of any property by arrest and detention in prison.
My lord, may kindly come to para 8, my lord. I have, of course, another judgment, my lord. When such this review and appeal is pending, my lord, normally the execution should be stayed, my lord.
But had you come in time, that of course. But there is a delay of not 1-2 days, 226 days.
Yes, my lord. That is for the trial court to, my lord, decide, my lord. Because if I have explained every delay, my lord, every delay in my condemnation petition, my lord.
Decide, but you should have approached it within time.
Yes, my lord. That I could not approach within time. That is why, my lord, I have to file this another application, misapplication for seeking condemnation of delay, my lord. If, my lord, holds that I had not approached the appropriate forum in, my lord, then, my lord, this providing section 5 in the limitation Act gets repeated, my lord. And more so, my lord.
Today I'll issue notice And then on the next date, of course, I'll give you a short date. Then you pray for the interview.
My lord, at least till returnable date, my lord. My lord, may kindly take up this matter on 21, my lord. Till then, my lord, I may be protected, my lord. Otherwise, my lord, my lord, may kindly. Yes, my lord. Facts of the case. The petitioner faces execution proceeding regarding an ex parte degree. Of course, mine was not ex parte degree, my lord. Claiming that a pending review petition may become in process if execution continues. She seeks a stay on the execution until the review petition is resolved. Issue whether execution proceedings should be stayed pending the disposal of a review petition filed by the petitioner challenging the degree.
Different. She has filed an application, but that was not considered. Your application was defective.
Yes.
Before the executive court.
My lord, from the heading is pending review petition justifies staying execution.
I mean, why should I go into the headings? Go to the judgment.
Yeah, judgment is also provides that normally if review is filed, the execution proceedings should not be.
Review is still not registered. Your appeal is not registered.
It is registered, my lord. It is registered, although the delay has not been controlled, my lord. It has been registered, my lord.
Otherwise, without, without condoning the delay, it should not even register.
Yes. It has not been granted by the appellate authority.
My lord, may kindly see the order, my lord. Passed by the Civil Judge Junior Division, my lord, which I have annexed 3, page number 23, my lord. Even the civil appeal has been registered, my lord. Miss case number.
Registered. Here I am seeing that.
Only notice has been issued, your lordship.
You have no right to be heard in the appeal.
If my lord,
Your delay.
if in such.
So what is the final, the order by the Assistant Commissioner to.
My lord, warrant has been issued, my lord.
Pay, they will put you inside, right?
Yes, my lord. After that, my lord, another impugn order has been passed, my lord. It was passed on 10 June 2025. This is a warrant of arrest, my lord, in the execution.
Where is 2-5 Keba decision?
My lord will find
It's 17, Your Lordship.
7.
7.
Type it,
Okay.
type.
The said the said amount of 7,80,000 was paid by Sri Senbi Romi, and it was decided in the Keba that the amount has to be paid to Mr. Senbi Robin by both the other contractors, including the petitioner. However, there was another Keba decision wherein it was decided that the petitioner would only pay rupees 7,80,000 to Mr. Senbi Romin. In view of the fact that the other partner was not included in the contract work, that was the reason he was not included, so he was supposed to pay.
My lord, all three of them were involved in the contract from my lord.
Unless- but then
in the
that-
first cover decision, my lord, the liability, my lord, what?
Was divided into two, and then after that it was only laid upon you.
Yes, my lord.
Yes,
Yes,
that is what I said.
yes.
Thereafter, on 14/5/2025, the learned assistant commissioner, additional deputy commissioner, in the execution petition number 1 of 2024, passed an order that the judgment debtor, that is the petitioner, was given the last chance for payment of the decreed amount to the decree holder.
Yeah.
Right, to
Yes.
the decree holder. It was also observed that if he does not pay the amount to the decree holder, he will be committed to civil prison for recovery of the said amount. And fixed the case on 10/6/2025. After that second Kabat decision and before the order dated 14/5, you write that execution proceedings was initiated. Thereafter, on 9/6/2025, the petitioner filed a civil appeal. No, the petitioner preferred to file an appeal against the Keba decision dated 9/10/23. But since there was a delay of 226 days, the petitioner also filed a miss case for condonation of the same. While order dated 9/6/2025, the notices were issued in the said miss case. Thereafter, on 10/6/2025, the petitioner intimated the additional deputy commissioner that he had preferred a civil appeal along with the said miss case and prayed for staying the execution proceeding. However, on 10th of June 2025, the Assistant Commissioner, West Siang District, issued an order for warrant of arrest in the said execution proceeding against the petitioner. Mr. D. Kamdu submits before this court that he has preferred an appeal against the second Keba decision. However, the Assistant Commissioner additional deputy commissioner, what, assistant commissioner, without considering the same, issued the warrant of arrest in the said execution proceeding. He also submitted that the execution proceeding was not according to Order 21 of the CPC. To substantiate his argument, he placed the decision of Maya Devi versus Rajendran Pillai, passed by the Honorable High Court of Kerala, in capital letter OP within bracket C 1860 of 2023. On the other hand, Ms. So-and-so, on behalf of respondent number 1, stated before this court that the appeal was filed very late, and it was filed only after the execution, after the order dated 10/6/2025, wherein in the execution petition, the assistant commissioner had directed the petitioner to pay the decretal amount.
14/5/2025, order dated.
14/5/2025, order dated 14. To pay the decretal amount. She also submitted that the miscase, the civil appeal, along with the miscase, was filed after the said order. And the condonation and the delay is yet to be condoned. As such, she states that there is nothing wrong with the order of the assistant commissioner dated 14/5/25, as well as the order issuing warrant of arrest. I've heard the parties and I've gone through the reports. It is noticed from the records that the petitioner had not filed the civil appeal within time. Full stop. Since they were aggrieved with the order of the Kebang they were aggrieved by the order of the Kebang passed on. When was the order? This second Kebang order? The second Kebang order was dated
9/10/2023.
9/10. Yes. Since they were aggrieved by the Kebang order dated 9/10/2023,
Page
they
90.
should have immediately filed the civil appeal as provided under the law. However, the counsel appearing for the petitioner states that the petitioners lived in a remote area and there was delay in filing the civil appeal for reasons for what valid for valid reasons. It is also noticed in the order dated 14/5/2025 that the objection petition filed by the petitioner was defective and was filed without following the legal principles and provisions under the CPC 1908. Further, it was noticed therein that the contents of the objection petition were all about facts of the case. It is noticed that although the petitioner were not vigilant with the rights in filing the appeal against the KEPA decision, this court, however, in the interest of justice, I'm staying this warrant, go and
Yes, madam.
do the needful.
Yes.
For the ends of justice, let him not be put in prison and all. Also, for this court, for the interest of justice, stays and suspends the order dated 10th of June 2025, by which a warrant of arrest was directed to be executed unless the petitioner pays the sum, the secretal amount of 7,80,000 till the next returnable date. Issue notice to respondent number, Miss so-and-so appears for respondent number 1, so no formal notice. Issue notice to respondent number 2, returnable within 3 weeks. Petitioner to take steps upon for service of notice upon respondent by registered post or usual process within a period of 3 days from today. Okay?
Extra copies, Your Lordship.
Extra copies may be furnished to her. Only for the, you were not vigilant, but only for the sake of that, you should not.
Yes, my lord, if my lord, it is to be, my lord, allowed to be executed, my lord, then filing of course, that civil appeal will be defeated, my lord. Otherwise, there will be nothing left, my lord, after the arrest of the petitioner.
Just, you do the needful.
My lord.
Okay? No.
The kind indulgence of ladyship. I apologize, ladyship, for appearing online.
No, it doesn't matter. The provision is there.
I am seeking kind indulgence to item number 21, my lord.
21.
Yes.
Okay.
By order dated 6/6/2025, this honorable court required a certain clarification as to why fresh appeal case was required to be registered when the direction passed by this court by order dated 14/7/2022 in CRP number 8/2020 had the effect of reviving the civil appeal number 138/2024. My lord, both of us were asked to seek a clarification from the learned trial court. I don't know who is appearing for the other side. If
I'll be appearing, Your Lordship.
yes. So, my lord, in this case, if the clarification has come, in that even my lord will kindly make an observation that clarification relating to the registration of 138/2024 of the CRP of the civil appeal in the learned trial court, then my lord will record that the clarification has been provided and list this matter for exhaustive hearing after summer break, my lord.
I'll just brief Your Lordship. Your Lordship, when this matter was heard, there were certain difficulties with regard to the number in the appeal, Your Lordship. Since the matter was transferred from one district to another district, therefore, there was a question with regard to clarification of the appeal number, Your Lordship. We have sought a clarification from the district and sessions court, who has given a clarification that by mistakenly the appeal number was changed to changed, Your Lordship.
What is the order where your clarification was sought for? Which is the order?
6/6/2025.
6/6/2025.
Yes.
By Justice
Okay.
UK Nair, ladies.
Acha. It is not clear as to why fresh appeal case was required to be registered and when the direction purport is got. Okay. So, right in item 21. In view of the order dated 6/6/2025, wherein a clarification was sought for as to why the fresh appeal case was required to be registered. When the directions passed by this court by order dated 14/7/2022 in CRP number 8 of 2020 had the effect of reviving the civil appeal number 138 of 2014. As per the said direction, a clarification was placed before this court by Ms. T. Ginny. You are for the
I'm for the respondent, Your Lordship.
appearing for the respondent, wherein it is stated, where is the?
The last paragraph, Your Lordship.
It is stated that due to inadvertence, many cases from the learned court of ADG, due to inadvertence, no, it was found that due to inadvertence and on admission of the staff, that on being transferred with many cases from the learned court of ADC Basar, the instant case was wrongly registered and given fresh number as BSR / CA-12 of 2022. It is also stated therein that it was also clarified that BSR's, the said fresh number, right? The said fresh number is to be treated as civil appeal number 138 of 14. And the order dated 9/8/2023 passed in the said fresh numbered case is to be treated as civil appeal 138 of 2014. The instruction given by the additional district and session judge, Basar Western Zone Leprada district, is kept on record. Okay. Now that the instruction has come, it is clarified it is 138, the numbering was wrong. So the matter can be taken up for hearing?
Yes, Your Lordship.
My lord, convenient date of my learned friend on the other side. Kindly
on-
make it after summer break.
On 5th of August, Your Lordship.
On the joint request of both the parties, list the matter on 5th of August.
My lord,
2025.
kindly
hearing.
continue the interim order.
Yes, for
Kindly.
hearing. The interim order passed earlier shall continue till the next date.
Much obliged, my lord.
Deeply.
What are these orders? Call them once, fatapat. Why it has come up for orders?
Yes, may I please, my lord? My lord,
Huh.
by this morning, I have received the NOC that the previous counsel for the petitioner, he has withdraw his wakalatnama. So I have filed a fresh wakalatnama. And one more thing is that, my lord, whether the previous counsel has taken the steps in regards to the respondents. I am not aware of that. So I may be allowed to take a fresh step.
Has not taken steps. So you take steps.
Yes, okay.
It is stated by Mr. So-and-so in item number so-and-so that the previous, the counsels appearing for the petitioner had withdrawn from the same and that he will file the he has filed the wakalatnama.
Yes.
That he has filed the wakalatnama on behalf of the petitioners. It is also noticed from the orders that the erstwhile counsels had not taken steps. So a direction. So Mr. So-and-so is directed to take steps. So the petitioner, okay, so Mr. So-and-so is directed to take steps for service of notice upon respondent number. How many respondents? Respondent number 2.
Two only,
No.
Yes.
You are there for 2. On the respondents by registered post with AD and all usual process.
And my lord, if there is any interim.
There is any increase.
Still is unable that.
No, there is no injury.
Lordship, it is there, Lordship, in the order 9-1.
The criminal revision is preferred against so-and-so, dated so-and-so in Jidma has been set aside. Issue notice appears.
No, Lordship, by the order they set aside, Lordship.
No, they are speaking about the The one that was set aside.
Yes, yes,
Dimma-
Lordship, sorry, Lordship, yes.
Dimma application.
Yes, Lordship.
There is no interim order here.
Yes, Lordship.
Okay, you take first steps.
TCR has called for Lordship, it has come, Lordship.
It has
Yes,
come. This is listed after 3 weeks.
3 weeks.
Obliged, Lordship.
Service report is received.
Yes, Lordship, for respondent number 2, Lordship, 2 and 3, Lordship. Lordship, here, Lordship, respondent number 3 is Lordship, minor, Lordship. This is,
Minor?
Lordship, yes, Lordship. So, LAC may be appointed, Lordship, because LAC may be appointed, Lordship.
No, 2 and 3 are who? Who are 2 and 3?
2 is Lordship. Actually, Lordship, this criminal evidence petition regarding the order, Lordship, whereby Lordship, respondent number 2, Lordship, he discharged from the this case, Lordship. Yes, Lordship, ordinary discharge order.
This is
So-
again discharge.
Yes, Lordship. So respondent number 2 is the Lordship against whom this discharge order was made, Lordship, but it was set aside, Lordship, by this honorable court.
But respondent number 2 is a minor.
No, 3 is minor, Lordship.
The respondent number 2 is a complainant, informant.
Their service is complete.
Lordship, service, Lordship, it is complete, Lordship. It has written back,
Service
Lordship.
report received in
Yes,
respect of
Lordship.
2 and 3, so and so. So when the service
Yes,
is
Lordship.
complete now, let it come up for, it is admitted.
Admission hearing. No, it is order, Lordship.
Take it. It is seen from the notice, if it is seen from the office note dated 28/5/2025, that service report in respect of respondent number 2 and 3 are complete. Ms. Hege appears for respondent number 1. List the matter after 2 weeks for admission hearing.
Also, there is an interim may be continued.
Interim is there.
Yes.
Yes, here it was, I
The
was.
interim order which is passed earlier.
Yes, I was a bit confused, Lordship, regarding.
So, passed earlier shall continue till the next date.
Obliged, Lordship.
Your Lordship, service upon respondent number sole respondents are
Yes.
easily aware
Is received.
or received.
So service is complete.
Complete.
There is only one respondent.
Yes, only.
So it is seen from the office note. There is an interim order.
Yes, yes.
It is seen from the office note dated 28/5/2025, that service report in respect of the sole respondent has been received.
Okay.
Which is marked as flag A. The matter to be listed after 2 weeks for admission hearing. The interim order
Order.
passed earlier shall continue till the next date.
Not in order, Your Honor, because in that may be fixed on orders, for orders.
It is not admitted, I think.
Yes, not admitted, because on next day, the council will appear and he may file a reply.
And after that, service is complete, but it is seen that no one has filed wakalat nama
Yes.
on behalf of the said respondent. Okay, and may be listed,
After,
not for admission hearing, cut
Yes.
that, listed after 2 weeks.
after. In the meantime, also,
Interim to continue.
deeply obliged.
My lordship,
Are
I'm
not completed.
not completed. As per the office note, it is not completed.
Await. You
Awaited, yes.
This is 36/25 only. Okay. It is seen from the office.
May I, Lordship?
Hmm?
Lordship,
You're appearing.
yeah, I'm for the respondent number 2.
Oh, then he is
Yeah,
appearing.
I filed the wakalatnama.
Okay.
Lordship, I pray 3 or 4 weeks may be given for filing the reply.
Okay. Although it is in the office note, it is stipulated that service upon respondent number 2 is not complete. However, Mr.
S.M. Singh.
S. So appears for respondent number 2. And it is seen that the service is complete in the present case. Respondent number 2 prays for 4 weeks time to prepare the case listed after 4 weeks. There's no interim order, right?
Yes.
After 4 weeks.
Take copies of the trial court records report. Trial court records have been received.
Trial court records have been received. So,
If my lord allows, I will place for disposal of the case. I will hardly take 3 minutes. I'll be very
Lordship,
short.
it
and
may be
specific.
lordship, admission hearing may be fixed lordship because time is
come
not
up, it will
right.
come
Yes.
up.
The stay is already there lordship.
Because the informant in the accused person, they are before your lordship, and the respondent, that the state of Arunachal Pradesh is being represented by PFIP.
No, this is for what? This is for quashing of the charge sheet and all. Due to paucity of time, let the matter be taken up after 2 weeks.
There's an interim order that has been.
Interim order, which passed earlier, shall continue until the next date.